appeal is allowed. The judgment and order passed by the Assistant Session Judge Gwalpara is hereby settled by that court, and the appearance be got.
Give him rest.
I do not find any substantive question of law to formulate, and accordingly the present Herrera appeal is dismissed. Its appeal stands dismissed, and judgment and order passed by the Honorable Special Judge Foxley is hereby affirmed. I find this not a fit case to apply to exercise power under Section 482 CRPC, and accordingly this instance.
May I please order? So, victim is item with 13 my lord. 1-3 my lord. Can this matter be taken after 2 weeks my lord? Or any date in the month of June my lord?
Yes. Why you need an adjournment?
Today we are not ready my lord.
Ready. Let's go ready.
There is an interim order my lord.
That is the reason why you are adjourning, na?
My lord.
Maple.
Is it a reason?
No my lord. No my lord. We are not ready today.
Maple. I beg to mention item not 34 my lord. Earlier 2 occasion matter was left over my lord. So my believe the updated my lord. The learned senior counsel is sir Sodhu argue this matter my lord. So your lordship convenience my lord. 34 my lord. 34 my lord. Upgrade my lord. And you will be there will be left long time action. Any your lordship any time my lord. 34 my lord. Orders matter my lord.
In order to follow.
Yes my lord.
Is there any petition?
Yes my lord.
They'll move the 389 application first.
Oh, 389
application is pending for bail.
Act 2 can. Act 2.
Hello, may I please lordship? I beg to mention for listing one I my lord. Earlier my lord 3-4 times listed but not heard my lord. Applicant is behind bar 1.5 year and conviction is 5 years my lord.
Tuesday can. Not Monday. Tuesday. Tuesday. 4th.
No, 4th. Then my lord.
No 4th.
After 4th my lord.
No, you will not be available on 4th.
Yes, I am not available on 4th.
5, 6, whatever.
6 my lord.
6.
May I please your lordship, I beg to mention item number 17. Kindly matter may fix after 2 weeks.
There is no. It is a bail hearing method.
Case record has come.
Case record is there. But you need 2 weeks.
Yes, lordship.
After 2 weeks, any date. It's on 48 days. It's on 46. Now, case record, and case record. It will be listed on 14th.
Okay. Bless your lordship.
May please your lordships, item number 7 lordship. List after 2 weeks please. And the petitioner lordship.
You're for the petitioner.
Petition.
The recruitment of
Deputy Lord. May please my lordship.
excuse me, whether was there any other entry? No.
No.
May please, my lordship. I beg to mention item number 36. ma'am.
Basic.
36. The matter may come up after 2 weeks, my lordship, as my learned senior advocate is out of station due to his some personal issues, ma'am.
Who is your senior counsel?
S.A. Ahmed.
It out. This chapter.
May I please, my lord? My lord, I beg to mention item number 40, my lord. Kindly,
40,
40, my lord.
40.
Kindly taken about 2, my lord.
See, we try. One matter is also at picked at 2.
Just after that matter, which was
So
picked at
let
2.
us see the other matters also there. So see, we're trying to.
Obliged.
We'll try to.
My lord, with the consent of the other side, I'd like to mention item number 5. May it be adjourned for today. May you be pleased to list it on 4th of June.
It is a maintenance matter, lordship. So they have not complied, so date may be fixed on 4th of
That's what he is saying that it will be fixed on 4th.
14th.
Okay. 4th of Pretty consistent.
Item number 22. Matter may be fixed for hearing. Actually, analyzed matter has already been discussed.
Column.
Yes.
It is in Oregon, but it should be in hearing column.
Yes, hearing. My other side is petitioner. I am a respondent.
Otherwise, reading.
Reading.
Lord. Service is also coming. He had appeared. It's a long pending case.
Oh,
Already
yes. With the certain matter.
13.
In that case, we need any. The LCR is also received. What is this? This is the record. Do you need any LCR and all? Because LCR most probably was not.
Was not called. Lord. Will not be required.
Actually, I am the respondent. If the petitioner is required, I am nothing to say.
What do you say? It's a criminal petition for quashing,
Lord.
or what?
Yes, question for question of affair.
Quashing of FIR.
Yes.
Then city will be required.
Lordship may be called for then.
So you
Well,
know
as per-
better if it is not
Lordship,
by
yes.
2013 matter.
Lordship.
So it may be fixed for hearing.
Lordship.
But the question is that if you need the because there was no stay order.
There was a stay. Lord.
There was a stay.
There was a stay.
Why then a copy of charge sheet dated so is also there?
As
My
per
lord,
the
what is
first
a
order, I
matter?
believe the
It is
law-
a matter relating to pertaining to election. Actually, one Okon Bora, the then minister in Congress government, he filed a false affidavit regarding age, criminal antecedent, and education qualification. That's why petitioner lodge and respondent lodge an affair against him for giving false affidavit and so and so. And also filed a lead petition. The lead petition has already been disposed of due to instructions. And this is a criminal proceeding is going on. And the present petitioner and accused filed criminal petition for challenging and questioning for the FIR.
No. It's okay. It is for the FIR or charge sheet is already filed. No.
No,
I believe
charge sheet not filed.
Not yet submitted.
Charge sheet has not been filed.
No.
As because the police has not taken any step, that's why.
Oh, it already stayed.
There is a stay order, Lord, as per the first order.
That's why record is necessary. Might
No, not record. The case diary will be.
Case diary will be there
Case
because
diary.
only FIR has been filed.
Hard. You are Mr.
V.A. Chaudhary, Lord.
Hard Mr. P. Chaudhary, appearing on behalf of A.M. Bora.
Lord.
Appearing on behalf of Mr. A.M. Bora. Clarify Bora. MS exam for the however, on verified case record, is there will be required for cooperative call for the case that this matter record. We are calling for the case diary. Case diary,
What is dispute PS?
Dispute.
Dispute. 13.6. We are fixing it on 13.6. Case diary is called for. Rest you will take. Oh, sorry.
The people. The interim may kindly be continued.
Was interim was there.
Yes.
Interim was there in its stay is there.
Lordship, that is why.
13.6. Interim be continued. Yes, Jahan, you take step for calling the case diary. In fact, it is the case of 2013. We are fixing it on 13.6.
Must have like.
Highly applied. Wait, please, Your Lordship. Lordship, this is a 439 bail application, Lordship. Yesterday's case, Lordship, item number 1, Lordship has granted bail, Lordship. It's an
Another
analogous
accused
place.
in that gold and fake currency
Lordship.
issue.
Oh, it is a fake currency, na?
No,
this
fake
is
currency,
gold.
no, nothing, Lordship. Gold was also not recovered from this petitioner, and the fake currency was not recovered from this petitioner, Lordship. Forwarding report, Lordship, will find on page 16, Lordship. Only photographs of Lordship fake gold, that is on ground of police remand, that is on page 17.
As far as
Point number 2.
Jahirul Haq, no?
Jahirul.
Itu কোনটো জাহিরুল হক না নহয় ফরওয়ার্ডিং
Forwarding
জাহিরুল হক
Page 17, Lordship. The ground for police remand is there. That only. He is neither named in the FIR, Lordship. Nothing was recovered from him, Lordship.
It will be named in FIR.
FIR is, Lordship, his name is not there in the FIR.
FIR only 2 persons name were there.
Safikul and
His name came out during investigation, I think, from the co-accused.
co-accused. Forwarding on 16. And 17, point number 2. Considering the length of detention, since Lordship has already perused the case diary, Lordship.
Yes, as far as his involvement is concerned, we are yet to see the case diary.
Case diary is different.
Otherwise, it's here. Yesterday,
Case
the matter
diary
was
It is
there.
forwarded in connection with this case only on the 11th of May.
Yes, Lordship.
Case for call for the case diary.
Lordship, case diary is here, Lordship. Yesterday, case diary is at
I don't have time.
Lordship, then I may allow to withdraw, Lordship, because other case is co-accused case is fixed before the court below, Lordship, tomorrow, Lordship.
Court period tomorrow.
Yes.
Okay.
I may allow to withdraw. Highly obliged.
Then.
Up to date, there is second bail application. Up to date, there is. Any
Case diary.
madam, any date, madam. 2 weeks of record.
Yes.
Dhubri, so
12th of June.
huh?
12th of June.
12th of June? Yes, 12th of June.
I am obliged.
Excuse me. Not dispute PS case, Boshishta PS case. 499 2013. Boshishta.
We'll see.
Must be.
May please, Your Lordship. This is
No, 18, sorry. Yes, 18.
in Sessions case, Lordship. Now the petitioner is before this honorable court.
My lord,
For grant of bail, Lordship.
their scan copy has been received. I could not go through it. After some time, it will be taken up.
Yes, yes.
After 10-15 minutes.
Oh.
My lord, after some time, my lord.
Huh?
One.
After some time. No, sir, who will do? Case there is there.
So, case diary is there. Your some and
No, my lord, super.
other in case counsel is there.
Yes, my lord. Item number 19 and 20 is concerned, they are on interim.
post 19 and 20.
19. And they have appeared before the IO. Their statements are recorded. And I have examined the medical report. 2 police personnel got injured, a simple injury. Basically, I am opposed to mob lynching. This is a pure case of mob lynching. An accident took place, police came, then people attacked the police personnel. Now, since they have already appeared before the IO, whether custodial interrogation is required or not, that is the only issue. Otherwise, injuries are simple. Both the injured persons, this is simple injury. Abrasion, swelling, bruise, this type of injury.
Yes, your petitions have already appeared.
Yes, my lord.
You are for 19?
Yes, my lord. Item number 21, perhaps, 3 cases are there, my lord.
19, 20, 21.
21.
You are for 19?
I am for 19.
Only for
because so far as the other petitions are concerned, my lord, their bill has been granted by this honorable court. So I have also got the order. I don't.
No. 21.
You are appealing for 19?
I am for 19.
Your petition has already appeared?
Appeared, my lord.
Mr. Das has already
Yes,
informed.
yes. So interim was granted, my lord. Then that may be kindly.
21, perhaps interim is not there, and I did not find his statement.
Okay, I'll see. Hard Mr.
A. Ali.
However, obtaining the order of effect for the and focus but he is granted with reflector. So that from the is that minor. However, I it's pending for CGM.
CGM Dhubri.
CGM Dhubri.
Milord.
Oh no, it's a. I mean,
This is anticipatory, milord.
Your anticipatory dated 6/5/2024 is.
Milord. I am obliged, milord.
You are appealing?
Yes, my lord.
Similar order.
20 and 21.
You appeared before the IO?
Yes, my lord.
You are MS?
R. Bora.
R. Bora.
R. Bora. Yes,
MS R. Bora koi diyo, baki order.
21 to
21.
So you asked your petitioner to cooperate the IO in further investigation?
Yes,
if his cooperation is required. Otherwise, your interim granted on 10/5/2024 if you have permitted. I don't know. So that's 21. It seems that it was also for.
Interim is there, no?
Interim is there, my lord.
A. Ali is also for 21. Is that good? Mr. A. Ali, the 19 wala.
Oh, yes. Oh, yes. No, 21 also milord R. Bora. He is the
21. Same order of you are here for in 21 also, no?
Yes, my lord.
Your petitioner's statement is not available. Whether he appeared or
My lord, appeared, my lord.
what is your instruction when he appeared? Because his order is of 15/5.
My lord, it will be taken after some time, my lord.
No statement is available.
I will
I
be
will
allowed to
find a
take
statement.
instruction, my lord.
Otherwise, that can be confirmed.
My lord, more or less same. Many people will not gather. Some miscreants will not instigated the people due to the occurrence took place. The accident took place actually. I literally watched it. Had there been reverse injury, then matter would have been something different.
RR Bora subject Doctor first I that Dodi the petitioner was paid on 15/5 from 15/5/2024. Excuse me, the last date of entry is when it
5 years. $18,500.
that the but the statement of is that I don't know. I would submit that is the same subject. I hope I because it's context with other part of the part hard order is of 10/5/2024. Sorry, 15/5/2024. The order is same.
Perhaps interim order was granted on 15/5, I think. That is why immediately after that.
Ask your petitioner to cooperate.
Obliged.
Made with the lordship.
Yes.
An additional affidavit was filed, whether it is on record, your lordship. The matter has already been compromised between the parties. It was lost out of vengeance and out of some misunderstanding, your lordship. An additional affidavit was filed on
Additional affidavit is
in record, your lordship.
The other party is otherwise not here today. You and
They may
Chettiya.
not be present because earlier they are not coming. The matter has been compromised. That is what has been brought on record by way of an additional affidavit.
no, it is your submission, but the other side is not available.
The last petition also they were not present.
He opened?
365.
Who was the informant come victim?
Informant is the father of the
Victim,
your lordship, and the victim is imputed as respondent number 3, your lordship. The allegation is that the petitioner who is the
What is his name?
lordship,
His name is?
Iqbal Hussain, name of the informant.
The name of the victim?
Iqbal Hussain Bodbui alias Akbar Hussain.
Iqbal Hussain.
Bodbui alias Akbar Hussain.
He was subsequently made party.
He was subsequently made party.
Whether any notice is
Yes, his notice has been duly served.
on 3. Yes. Them appeared that the presence is to be required.
Otherwise,
yes.
compromise can be entered into. These are 365 cases. But then let the other party come. They also, if they say, actually there is a compromise then.
Because name of
On the
two
earlier-
counsels are there for the respondent, private respondent. Name of two counsels are there available.
Earlier
If you can inform,
I think whether they have any instruction. Last occasion also, since
But
last.
have you furnished a copy of your, affidavit before the IO also? Then
No.
we may, that may come in the case diary also.
No, we have not furnished.
No, before IO, you have not furnished.
No. Since the matter is sub
Copy
judice.
before the IO also, because you are on bail, I think.
No, actually, matter was charge sheeted, Your Lordship.
Oh, it is already charged.
Charge sheeted. And someone was issued up to that stage only. At that stage, we have approached this honorable court. There is a stay also, Your Lordship.
It's a non-compoundable offence, so they have to come to the High Court. So, he can give it a try to contact Mr. Chetty or Halloy.
There are no more.
So even Chetya and the Hello is there.
On last many occasions also they did not appear, Your Lordship. And I think since the matter has been compromised, the respondent might not have also
How can
given
we
any
say
instruction.
your submission?
It was a case of love affairs, Your Lordship. And then a case of kidnap,
Maybe.
Lordship.
But in their absence, any order passed will not be very fair. So if they don't come, then Lordship can appoint one amicus or someone. But without their representation, the other side, compound
Or
will
otherwise we
be
have to
risky.
also take his record.
Records are there.
Records are here.
Present.
Records, there will be no,
There will be nothing.
there will be
It
nothing
against
as far
them
as
only.
compromise is concerned.
No, indeed, the case record itself, there will be, the materials will be available against them only.
Against
because they are
them.
innocent. That's why
Witnesses will depose.
I guess. Statement of the witnesses, they are kidnapped. So compromise there can be, of course, but the question is that their presence will be required.
He can get the phone numbers in the directory and give it
May
a try.
fix it some other day. I'll try if I can get them.
Just try it, because if this matter has already been compromised, state also have no objection in quashing the matter. If it is a love affair or whatever.
Lordship.
They are married now? No.
They're married.
With each other or?
They're married.
No, married with each other or with someone else?
Married with each other.
Each other.
Married.
Then
they're staying together now.
Lordship.
So why she can come here?
Yes.
In spite of having this, the advocate, she can also come.
Who, Your Lordship? Petitioner
No, the respondent.
The respondent.
or respondent?
The victim or respondent. What?
Victim is the daughter, not daughter, son. They said that they have kidnapped the petitioner, that is the lady, she has kidnapped her son. Allegation is otherwise, Your Lordship. The father has said that the son has been kidnapped by the petitioner number 1, who is the lady.
Oh. Son is kidnapped.
Son is kidnapped. Son is kidnapped.
Okay, then the informant or the son who can come here.
So
The
these
respondent number 2 or 3, they can appear also.
these counsels are appearing for the son.
No, both. Right?
Both.
I mean, 3, the son is also made as a party in this case as respondent number 3.
But I think he is appearing for both the lady and the son. Okay.
No.
There is no another
Son, father and son.
father. It is Musammad?
No, she is the accused. The allegation is that she has
And
kidnapped the
another?
son. Yeah, her brother.
Oh, her
FIR is
brother.
against the petitioner and her brother. Allegation is that they have kidnapped the son of the respondent number 2.
And by the way, respondent number 3 is also made a party.
Achha.
So both respondent number 2 and 3 most probably they were represented by the 2 councils. Or otherwise on the next day we can, because one affidavit is there, but who signed this one, the identification is necessary.
We can be doubly sure after they say. So he can give it a try by
I'll try, Your
checking the
Lordship.
phone numbers from the directory.
Let's record that.
Last few occasions they are not appearing.
You need 1 week, 3 days or how it?
1 week.
One. Pada itu देखो the duty name on council reflect the council. No one has represented number 2. And it's reflected. we have to repeat it. In otherwise, next date, if they remain absent, amicus may be appointed. Or even in spite of in absence of amicus, also it may be.
Planet PP is there. I think amicus is also not required.
No, in order
For
to
instruction.
contact the
Okay.
boy and the
Or I may ask them to come personally if they may also be.
personal appearance will also do.
Okay, it will be listed after what?
Interim may continue.
Interim was there. Interim may continue.
Oblige, Lordship.
It is. Over.
Salu, only one thing that I get in the case diary is that the fingerprint matched.
And
Chance fingerprint.
chance fingerprint, and in this respect, my submission is that the sample from which the fingerprint was compared, there has not been seized. I have gone through the
Stainless steel container.
Yeah.
Acha.
because I have been
This is
conducting
a
the case
burglary
there
case
also.
along with 302. Burglary case along with 302.
And I have been
They
conducting the
went-
trial also, their lordship, and I have gone through the entire material available in the record supplied to us. Therein, surprisingly, we have found that there is a actually report of the FSL saying that the fingerprint is matched. But surprisingly, the stainless steel glass, on the basis of which this was compared, this said item has not been seized. No seizure. No seizure at all.
Oh, that I have not checked. It was sent to the FSL,
Yeah.
that steel container.
And that is
I
the
thought
aspect of
it
the
is
trial.
seized. Of course, I did not check the
No,
seizure
no,
list.
no, that has not been seized. I have gone through it.
The stage of case that
Stage 21 witnesses are there almost, out of whom till 29/5, 6 numbers of witnesses have been examined. There is no eyewitness. And on 29/5, the doctor has been examined.
This is head injury.
Yeah, this is head injury caused by blunt force impact.
In the records, there are only deposition of 3-4 witnesses.
No, I have annexed. I have annexed. I have annexed.
Witness নাপালো।
No, Satana Pasta Asile. I have annexed 4 witnesses, the deposition of 4 witnesses, and on 29/5, the doctor has been examined.
5 witnesses you have annexed.
Yeah, 5 witnesses I have annexed.
In the case record, I could get only 3 or 4 witnesses
there-
statement.
There should be, because I have obtained this.
Acha, acha. Ah, yes, it must have come before that.
Yeah.
Oh, baki baho.
And already for last 15 months, the accused person is behind the bar. And the accused was arrested, lordship, after about 1 year of the occurrence, lordship. Only purely on suspicion, lordship. There is no eyewitness, nothing.
There are 2 accused.
Yes, there are 4 accused.
There
I'm
are
not
5
for
of
the
them. Oh,
No,
what? Oh.
total 4 numbers of accused are facing trial. 1 is juvenile and 3 are facing trial before the Additional Sessions Act. And I am for one of them.
Otherwise, witnesses' statement will not count because they are all hearsay. They had just come and had seen. And
this case was pretty. It was dismissed.
Lordship had dismissed it.
At this stage, 1 or 2 witnesses were examined, and by now 6
Three.
witnesses have been
3 witnesses were
examined.
examined. Yes.
And so far the evidence of these witnesses, there is no implication of the accused person, lordship. Only there is the
Fingerprint.
yeah, there is the fingerprint, and surprisingly the stainless steel glass was not seized. So there is a very less chance of conviction, lordship, in this case. So on any condition, lordship,
That Caesar list I have not gone through. Lordship may look into. I some Caesar list में देखा ना पर. ना ना सर.
this is a famous testing method. One is আপুনি জানে আচল
মই ফটোত চাইছো নহয় চিজাৰ লিষ্টখন নাচালে
open area for recommend. They get no no.
ডেইলি দিয়ে ভাত একো ন He has been inside since long. Okay, to go absconded from state. But those will not matter. Sue কৰিলে বাৰু, but the body was found inside mosquito net. তাৰমানে চব হেফাজত আপুনি তাক মাৰিবই আহিছিল তাক Chetia is involved in something. One surprising fact that I get here is the body was found inside the mosquito net. So what it shows is that he did not come to know when the looting and all were going on, and he was simply found dead in over on his bed inside the mosquito net. Severe head injury. So what it shows is that, what transpires is that people had come to kill him, or that was the intention. It is not a case where he had come out and then, in order to save from their being recognized, they killed him. Not a case. Of course, those things will come out during the trial. As far as bail is concerned, I think till date the only evidence is fingerprint. And what my learned.
submission, Lordship, kindly. Yes, my submission is that any condition may be imposed. He is a local resident. So, on imposing any condition, he may be granted bail, Lordship, because actually at the end of the day, if he is acquitted, then he will be. And if you take long time, Lordship, then my one submission may be considered that the trial may be speed up. In a speedy manner, it may go because the dates are given after 1 month or 1 month and 10 days. And in this manner, if the case proceeds, then it will take 2 years almost. So, just to clear case of still live.
Habla.
My Lord, so far item 4 is concerned, the impugned order is categorically stated that section 468 and 477A of IPC is not covered by PMLA. That is the reason why actually the case was retained and the petition was rejected there by the learned CBI court.
Actually, my lord, if item number
Other
6
things
is taken
are-
up, it would be convenient, my lord.
No. What is in
My submission was
number
that
4?
4
This
for
is
4.
also petition for quashing.
Actually, my case is not analogous to those in that sense, because I was accused number 1 and I was charged with 477A and 468. But so far the other cases are concerned, there is a Supreme Court case pending. That is what will be submitted by learned friends.
So what about yours?
My lord?
Ms. Gayan, what you want to see is in regards to 4?
Actually, my lord, in item, if your lordship takes up item 6 first.
Item
6. There I am the petitioner.
No. You are not pressing the item 4.
Not in practice. I will be pressing in the sense, lordship, because the case.
It will be covered, my lord.
The case is pending there and still continuing and on the verge of completion of evidence. So far, these petitions are pending for last 7 years here. Now, in view of Apex Court Lordship, tendency of Apex Court case, your Lordship may decide the case. I have no problem.
No. As per your submission in item number 4, it is in the verge of completion now.
Completion. All the accused are already there in the same case. But my case is different. I am charged with 2 more sections which are not covered by PMLA.
Kindly take item number 6 first, my lord. Item number 6, my lord.
In this case, my lord, what has happened?
the petitioner is facing trial in both the forum, one before the special court and one before the CBI court, for the same offence, my lord. The offence alleged was in 2005. So, my lord, what we are before this court, my lord, on the ground that on the same offence, my lord, inquiry was conducted by CBI, same set of evidence, same allegations, my lord, same charges. Subsequently, my lord, in 2015, the PMLA, the special court, in the special court, the petitioner was implicated there. Now, my lord, first argument was that both the forums cannot pursue together for the same offence and the same set of allegation and same investigation. And the second ground on which, my lord, I am before this honourable court is this, my lord. And on the date of when the charges were made by the
investigation was done by CBI.
CBI initially. So subsequently, when PMLA has filed the charges, at that point of time, my lord, the offence was committed in 2005. That point of time, PMLA Act was not in force, and therefore it was not a scheduled offence. And hence, my lord, my submission before this court is, my lord, that it cannot constitute an offence under PMLA, and because it was not a scheduled offence. But in a similar line, my lord, other cases are also filed before this court, my lord. If I may mention, my lord, one criminal petition number 180 of 2019. My lord, I am forwarding the copy of the judgment. In this case, my lord, well, issuing a notice of motion, lordship will see, dated 22/2/2019.
Which one?
My lord, it is lordship takes up 180 of 2019 first.
Yes.
Order dated 22/2/2019. The alleged offence was not a scheduled offence under Prevention of Money Laundering Act on the date on which the alleged occurrence had taken place, and therefore the petitioner could not have been tried under the provisions of PMLA. So this was the contention in this case also. Here, my lord, this further proceedings were stayed. Subsequently, my lord, this case along with other cases are taken up, my lord, in the other judgment, my lord. 1020 is the leading case, my lord. 1020 of 2018. Here, my lord, lordship comes to page 11 of this, my lord. Order dated 25/1/24. Here, further proceedings in all these cases have been stayed in view of the pendency of the case before the apex court. So the issue is taken up to the apex court now. The matter is pending before apex court, my lord. So in this line, my lord, I am praying for just a similar order like this as on 25/1/2024, because this case was not tagged with the other cases, my lord.
My lord, that stay has bin given on the basis of Obrakulam cases, my lord, that is pending before the Supreme Court. Here the Supreme Court clearly stated, my lord, that is that admitted on the 24/7/2017. That case was admitted. On that case, the Supreme Court clearly said in the leave granted. In the meantime, the impugned judgment and order will not operate as a precedent. That means, my lord, that order, that Karnataka High Court order has been challenged before the Supreme Court, and Supreme Court said that has not been precedent, my lord. That is my humble submission before for stay of this case, my lord. And Vijay Madanlal case, that has been, the issue is that that is not that issue is that, my lord.
Oh, grounds in this case.
Yes, grounds. That offence was that the offence was before the amendment of this PMLA Act. Yes, 2001. My lord, that is in this regard, my lord. I want to place that Vijay Madanlal case, my lord, that was passed in 2022, my lord. In that case, my lord, in paragraph that is one of
If I may pray, my lord, for the final hearing, it may come up along with other similar cases. But for the time being, my lord, since stay is operating in all other cases of similar nature, let this matter also be tagged with the other cases, and it may be heard finally. And for the time being, a similar order may be passed suspending the further proceedings, my lord, as has been done in other cases.
My lord, my humble submission that may be tagged, my lord, but stay because it is in evidence case, my lord, case cases.
No. Charges are not yet framed. No.
In that
But
case,
in the court of CBI, what is it?
In the court of CBI, it is proceeding, my lord. That we don't have any objection. Only in the special court, my lord. Charges are yet to be framed.
And my lord, regarding the SARS, my lord, I want to point out two things, my lord. And at this stage, my lord, court cannot interfere while in the stage of SARS, my lord. That is in.
My lord, why similar treatment should not be given to me? In all other cases, my lord, at least here some 10 cases have been referred, whatever judgment I have placed before your lordship. A minimum 10 cases have been referred, my lord. All these cases have been taken together. So my prayer is my case also may be tagged up with along with these matters and taken up together, my lord.
From the very beginning, this case is, my lord, not tagged with that case, my lord, from the very beginning. And regarding the SARS, at the stage of SARS, my lord, I want to point out one Supreme Court judgment, that is, my lord, in paragraph 3.1, my lord, case 4. Both the learned counsel appearing on behalf of the respective accused have made a submission on merit of the allegation made against each accused. However, all those submissions are the defense which are required to be considered during the trial. Therefore, we are not elaborately dealing with or considering the submission made on behalf of CBI as well as the accused on merit on allegation against the accused as an observation of the this court may affect either or the parties during the trial, my lord. Here, my lord, having gone through the impugned common judgment order passed by the High Court coercing the criminal proceeding and discharging the accused, we are of the opinion that High Court has exceeded in its jurisdiction in coercing the entire criminal proceeding in exercise the limited power under Section 482 CRPC in exercise the power under 226 of the Constitution of India.
But it's okay. It's there. But the condition is there that from their submission, that's what I have understood, that the matters have been pending before the apex court.
Yes, ma'am. That is
in that conflict. Can it be stayed till the result of any opinion from the apex court comes? In regards to, especially in regards to the PMLA case, other CPI most probably is proceeding.
It is proceeding.
That may be done. I think otherwise, if you need any further reading in that case, I am ready.
12 cases
but
are
if
there.
the matters have been pending before the apex court, suppose.
That is pending.
That is pending.
That is pending. So, but that court observation of the court that should not be precedent, my lord. That is the observation of the Supreme Court, my lord. My lord,
that is all right. But my lord, this court has also said that until the apex court decides this issue, all the other, I have placed that it order dated 25/1/24. 12 cases are tagged together here, my lord. Same nature.
it's not legible, but here that order of the Supreme Court. Printout is not legible, but here that Supreme Court said the order of the Karnataka High Court will not precede it. In second paragraph.
That's okay. Not, that the other matters that tag, suppose.
Yes.
Or if those are created with the
Supreme Court
court or the apex court, that case can be considered. Otherwise, they will be the views may be different or
different. That's right, my lord.
so any expectation of the result from the Supreme Court,
That I am not aware of.
or when any date is fixed or anything. Do you have any idea?
No.
not.
I have to take picture, but I have to search whether the date is fixed or not.
Or registry can be directed put up the matter immediately after the, just because we cannot fix any day that it would be not required for us. So in that case,
And I'm just praying for a similar order like this, my lord. Whatever has been, if they want to modify, you can modify this order, my lord, what has been passed in other 12 cases, my lord. But 12 cases are taken together on the same issue. Some order has been passed by different treatment for me, my lord. And tomorrow is the date for fixing of, framing of charge before the special court. So this matter also can be treated similarly, my lord, as has been done in other 12 cases. There are 12 cases under reference, my lord. There is no reason, my lord, why this case can be treated
now
separately.
presently before this court, how many matters are there? 4?
Only
5 and 6? Or?
No, 4 and 6.
4 and
Only
6.
4, and in this regard, only 6 is
Only
there.
6.
Only 6. 4 is separate.
Somehow, my lord, this case was not tagged with the other cases, my lord, similar cases.
In that case, it would be proper to place the matter in the appropriate bench that the other matters have been tagged there. In 12 numbers of cases have already been tagged. So can it give us an order to appropriate bench? Can I push today or by Monday also? Yes. That can be done, I think. Because these 12 matters have been tagged and similar kind of order, suppose we want that different kind of order. In that case, it may before appropriate bench that I try to hold up. The other
Monday
get back an order.
Monday, yes, ma'am. Monday or Tuesday. Not Monday, not Tuesday. Monday. Monday.
Tuesday she will be busy, my lord. Result day.
Huh? No, not for that. Tuesday I have case in tasteful
For
food.
Tuesday is
No, not for tasteful. Tasteful food I have. What?
She will be busy, my lord.
I'll be in tasteful on Tuesday. I'll be in tasteful 14. That's right. Yes. Much of that.
Madam, so far 4 is concerned, item number 4.
Yes, ma'am.
So far, my lord, so far item number 4 is concerned. Item number 4. Let me be listed separately, my lord. Actually, my case has, in fact,
Yes. Not weak also. It is
It's
already
not weak,
separate.
yes, ma'am. Let me
Because
be-
4 is not tagged with 6, in fact.
Yes.
It is separate. It is your submission in 4 now.
on a separate date.
Yes, ma'am.
Separate. Otherwise, it matters.
In the middle, June
Please
month.
allow me these cases almost regularly.
Oh, okay.
Yes.
So, June any date?
Yes.
11 June?
No, 11, not any other date against 11, 13 June.
Other cases may be tested, but mine
No,
Then only for
your
this,
will
only
be
four.
segregated.
only four, yes.
Your only four will be segregated. 13th of June?
Yes. Must apply, sir.
Apply.
Item 6 is on Monday, 3rd of June. Item 6, 3rd of June. Or could it be the tag which order? Oh, list come on it. Where is the list? Acha, it is. Okay.
May I please your lordship? My senior is lagged in another court. Only pass over the matters for time being.
Hello, I am appearing on behalf of restaurant number 2.
Who is your senior?
Restaurant number 2.
Lagged in another court. Court
No,
number
who is your
1.
senior?
Wasim Samoa.
Akhil Kumar.
Tuesday law. Tuesday.
No, আজি লব
আজি মানে বেলেগ কাম ফিক্স আছে
Sir, আজি লব
আৰু আজি লৈছে মই I may not be available. Well, I may have some
You decide yourself and put down to
I am ready to accommodate him, but I have another court case in another court. I may not be in a position to
You
come.
just take instruction from your senior. He will sit for 5-10 days.
Okay.
Just take another. He may be busy in other way. So he, as per him, he wants Tuesday. Tuesday may be fit.
Okay,
if he is okay. Just inform us within 5 days. I think item 9, safety is also there, I think, in item 9. All are private restaurants. In item 9, you are there?
Item 9, no. We are not.
On the last occasion, that is on 13/3, you most probably paid for an adjournment. On 13/3, you paid for an adjournment.
Maybe.
Yes. Thereafter,
Today the matter is fixed for admission hearing, ma'am.
yes.
So it's an appeal from order of acquittal passed by the learned appellate court below. So special leave was sought and same was granted, allowed by this honorable court, and accordingly this has come up for admission. I have gone through the impugned order, judgment and order, which is available at page 26 of my memorandum of appeal. My lord, I have gone through the...
Have you furnished the memo of appeal to the other side?
Yes, memo of appeal has already been given to the other side.
Because in one order, it has been reflected that they have not submitted.
Yes, it was immediately furnished to them.
So this is the judgment. Page 27.
Page 26, then 27. My lord, I have seen a certain observation made by the learned appellate court below, and which will definitely require, a discussion about the, and that too in the touchstone of the, ratio laid down in very many cases, of the apex court, my lord.
What
regarding
was this about? It was based on under which section? Cases of? What the term case?
Check bounce.
Okay.
So once the LCR comes, then it will be easier for to.
Okay, then we'll admit the appeal.
Yes.
Name of court advocate of has been admitted, we are calling for the LCR. Immediately after LCR, if you receipt of the LCR, that will be listed.
Yes. Applies.
Milord, it's a case regarding the maintenance, Milord. I have not been paid a single penny as maintenance since 2009. So I am a bit in a hurry, but my learned senior friend is saying that he is appearing for the first time today.
The question is whether she is at all entitled to get maintenance in view of the decision of the civil court. On the other hand, my lord, they relied certain decision of Supreme Court saying that, my lord, divorce wife is equally entitled, but there are some preconditions. So I want to like to place on record certain decision, my lord. Today, my lord, for first time I am going to appear. So I need
Can
some
it be on
time
11th of June, Milord?
And same question is pending before division bench, my lord. Matter was referred to division bench. Whether in view of the Shavan's case, subsequent decision of Supreme Court, Shavan's case was overruled, saying that they are equally entitled. Then after in 2020, Supreme Court says they may be entitled, but there are certain preconditions. It must not be.
Preconditions have been complied with the answer.
Maybe on 11th June, Milord. If not in...
Because it requires some adjudication.
Tuesday.
It will be Tuesday.
Yeah.
Then if the admissions is maybe disposed of. That's
My lord.
fine. 11th.
I'm blessed. I'm grateful.
May I please your This is also an appeal against the order of acquittal, Lordship, passed by the learned JMFC Udalguri, Lordship, whereby the respondent number 2 was acquitted under section 354 and 294, Lordship. Overwhelming evidence against the accused person, Lordship. The own brother of the accused person testified against him, but since the entire allegation pertains to a Facebook post, Lordship, which was uploaded by the accused person, Lordship, there are many phases of the investigation which the IO did not go through, and the main investigating officer who conducted the investigation, the prayer was made by the public prosecutor that his evidence is not required. But he was the person, Lordship, he was the investigating officer who had conducted the significant part of the investigation. And the person who was examined, the IO who was examined, Lordship, he did not take part in the investigation at all. He came at the later stage of the investigation and submitted the charge sheet, Lordship. And as far as the evidence is concerned, Lordship, the evidence of PW1, from the evidence of PW1, who is the brother of the own accused person, he has himself stated that it is my own brother who has uploaded the objectionable post against the informant's wife, who is the appellant before your Lordship. Already there was a leave has been granted, Lordship, it has come up for admission.
Most probably, let us the matter be admitted back. Because the name, for the respondent number,
The respondent number 2 name is shown, Lord.
names are shown.
Yes, Lord.
But,
Their name.
The matter be admitted, we may hear the matter. In
Yes,
the
yes,
meantime,
yes.
we'll call for a case record.
Yes, yes.
Order. The respondent number it has come from
Udalguri.
So we are fixing it after 4 affidavit.
Obliged.
I am appealing for the respondent number 2, Lordship.
Respondent number 2.
So, she is lodged complaint under DAV Act. They approach for passing of the scene on the ground that they are not living, they are living separately. And they are the brother-in-law of present petitioner, respondent number 2. and sufficient materials are there against them to proceed against them.
That's the detection now.
They are avoiding.
That's they were there.
Maybe it's on Tuesday or
They may not be possible. I think almost
then
too many cases are being treated.
Then let's say the 11th of June, Tuesday.
11. You are appearing in this case on personal claim?
Yes, as a person.
Okay. This track record and on 11.
Much of it. This will be taken up after some time. Mr. Sojit Das will appear, my lord. After some time.
Your partner will appear.
Yes, my lord. He is in legs in court number 12, my lord. Date of this.
May I please, Your Lordship? In this case, Lordship, the vehicle of the petitioner was taken away by the respondent number 2 without any prior intimation. Yes, Lordship, this is Tata Motors Finance Limited, the financer of the vehicle, but taken away on the pretext that there was some default in payment of the installment. And on that view of the matter, the vehicle was taken away without prior intimation to the petitioner. And accordingly, an FIR was lodged. When I the copy of the FIR, Lordship, it is at page number 20. The contention of the FIR is at page number 23. Page number 23, Lordship. Lordship, page number 23, the last paragraph. Fact is that the last paragraph is that mentioned. The fact is that in the year 2021, myself purchased the said vehicle on finance from Tata Motors Finance Limited in the year 31/5/2021. At the time of purchase, accused number 226 taken more than 100 signatures in the agreement book in addition to 4-5 blank sheet affixed revenue stamp on it in a hurried manner. 3 numbers of signed blank checks were also being kept in their custody stating their formality. Now in the next page it has been mentioned that myself become the absolute owner and possessor of the vehicle, below mentioned vehicle, and I have paid EMI regularly without delay and default, but only 2-3 installments myself failed to pay during Assam Meghalaya strike and on natural calamities. Lastly, without prior intimation on dated 22/12/2022, the accused number 2 to Ford along recovery agents came to my residence and forcibly illegally lifted without providing any notice seizure paper vehicle inventory. On the very next day, myself visited along with my friend to know the reason for lifting the said vehicle. Then accept accused number 1 and 6 in harsh manner directed me to pay rupees 7 lakhs for releasing the vehicle. On good faith, I have paid total amount of rupees 7,07,880 only on their further demand. Annexure 2A, 2B, 2C is the copy of the money received, but accused number 2 to 5 for the unlawful gain jointly cheated me for releasing the vehicle in my favor and keeping me in dark. The vehicle secretly released to accused number 5 with the direction of 2, 3, 4, 5 illegally removed my vehicle, number such and such, number plate. So this is the basic allegation in the FIR Lordship. This amount, the defaulted amount, actually the EMI certain amounts were not paid, and that was actually received by the respondent number 2, the financer. Even then, Lordship, on 22/12/2022, without any prior intimation, without any knowledge, without giving any prior notice, the vehicle was lifted. So accordingly, the FIR was lodged and it was registered under section 406 and 420. Now the police seized the vehicle. When the police seized the vehicle, this vehicle was lying in the police station. Then the petitioner has filed an application, Lordship, kindly see annexure 3, page number 26. The application was filed under section 457 for Jimma of the vehicle. Jimma of the vehicle, Lordship. In paragraph number 4, page number 27, Lordship. Paragraph number 4, it has been mentioned that recently on 25/2023, the Silchar PS seized the vehicle from Lumsung police station and parked at Arunachal town outpost in open area. The below scheduled vehicle is recovered by police and kept in open area and continuing damaging by the extreme sun heat and rain, and shall further cause damage due to thunderstorm, earthquake and other natural calamities. So that is the contention in the application. Now, After this application was filed, Lordship, the respondent number 2, they had also filed one petition under section 457. It is at page number 31. Page number 31, Lordship, and there also they had prayed, the financier had prayed for necessary order for granting custody and GMA of the vehicle. Now the petition that was previously filed by the petitioner, that was not taken into account by the learned trial court, and the learned trial court, Lordship, has passed an order at page number 37, annexure 5, on 19/6/2023, Lordship. This is the order that has been passed. I am just referring to one paragraph of this learned trial code. It is at page number 38, Lordship, the next page. In the third paragraph, it has been mentioned. It is note toward the
order you have challenged.
Yes, Lordship, 19/6 order has been challenged. Because two applications were filed, Lordship. The application of by the petitioner
was not even considered, and the other application was
exactly, Lordship.
Just for 5 minutes.
Yes, Lordship. Definitely.
Actually, I am having some medicine.
The third paragraph, it has been observed by the learned trial court. It is noteworthy to mention herein that while deciding the interim custody of the seized article, which is subject matter of offence under investigation, a criminal court is not supposed to conduct detailed inquiry regarding the ownership of the seized article. In the instant case, as per the loan cum hypothecation cum guarantee agreement, both the petitioners, namely the Abdul Qadir and the informant, and Tata Motors Limited, are rightful owner of the seized vehicle. So the learned trial court came to a finding that both the petitioners are the rightful owner of the seized vehicle. Now in the next paragraph it is mentioned, the only consideration left for consideration by this court is the safe custody of the seized vehicle, accordingly taking into note of the peculiar nature of the dispute between the parties and for the interest of the safe custody of the seized vehicle. The prayer of the petitioner by number such and such is rejected, and the objection and the prayer in such and such are allowed. So there is no finding with regard to the fact why it has been rejected and why the other one has been allowed. And there is also no finding with regard to the fact how this trial court came to a finding that if it goes in the hand of the financer, it will be in the safe custody. Because of the fact at the time of filing the application, they have already mentioned that it has been sold in auction to another person who is also the accused in the FIR. Now the fact is that, Lordship, this why the hypothecation agreement was there, because the hire purchase agreement is not there, the hypothecation agreement. Now in view of that hypothecation agreement, they have entered into an arbitration and proceeding. Now as per that arbitration proceeding, award has been passed. This is an ex parte award, no notice never been served upon the petitioner. There is no document, they have not annexed any document in their application also. So never issued any notice to the petitioner. In that view of the matter, when the award has been passed, there is a procedure of recovery of the awarded amount. That has also been flouted by the respondent number 2, because the awarded amount is with regard to a certain amount of 33 lakh. If your Lordship kindly see the petition that has been filed by the respondent number 2, the Tata Finance Limited, it is at page number 25, 30, Lordship. In page number 30, the operative portion, if I read the operative portion in paragraph number 3 at page number 32, page number 32, paragraph 3, Lordship.
Yes.
Paragraph 3, the petitioner begs to state that as per the said loan agreement, the said Abdul Qadir was required to pay all the EMIs regularly on time, but unfortunately he was very irregular in paying the EMIs, and in fact there is a huge outstanding against his loan account. Even on repeated requests being made by the various representatives of the petitioner, the said borrower have bothered to pay the EMIs. As on 25/12, this is the important, Lordship, as on 25/12/2022, an amount of rupees 4,17,610 rupees was accrued as overdue against the said loan account. So this is the amount, 4,17,610. Now the date is important on 25/12/2022. Now the vehicle was lifted from the premises of the petitioner. That was on 22nd of December, 3 days prior to that particular amount that has accrued. And in between that, Lordship, this 4,17,000 was the accrued overdue. but the petitioner has paid. It is specifically mentioned in the FIR, Lordship. I'm just taking again to this FIR. At page number 24, it has been mentioned that he has paid a sum of rupees 7,07,880. And the 7 lakh, the amount which is overdue, if it has been paid, then there is no valid reason for lifting of the vehicle. And the lifting of the vehicle from the residence of the petitioner without any prior intimation, without serving any notice, and that too based on an award passed by the arbitrator. Now the arbitrator, the award passed by the arbitrator, there is a procedure, there is a legal procedure for execution of the award. There has never been done. No notice was served. That amounts to lifting of the vehicle. It's a case of theft. And that is the reason why, Lordship, when the FIR was lodged, it has been registered under section 406 and 420. It's a cheating under 406, criminal breach of trust. And that this particular aspect of the matter with regard to the FIR and the prayer made for the vehicle which was lying in the police station was not taken into consideration by the learned trial court, Lordship. And in a mechanical manner, Lordship, the order has been passed because the finding is there with regard to the fact that the criminal court cannot decide who is the owner of the vehicle. If this particular thing cannot be taken into account with regard to who is the owner, actual owner of the vehicle, then how come the Tata Finance Limited has been handed over the possession of the vehicle? That is the basic issue in this particular criminal petition, Lordship. And I've just pointed out the fact that this amount, since the amount has already been clear, there is no overdue as such, because it is the admitted position from the FIR. And what they have stated in their objection and in their application also, on a particular day, that is on 25/12/2022, the overdue was 4 lakh something. So I paid more than the overdue amount. So in that view of the matter, Lordship, there was no overdue on the part of the petitioner. If there was no overdue, because the arbitration award with regard to the whole amount, 33,55,220. So that amount has been passed, the arbitration award was passed without any notice, without serving any notice. And lifting of a vehicle from the premises of the petitioner, that amounts to theft. So in the theft was there, accordingly FIR was registered, the police picked up recovered the vehicle and it was kept in the custody of the police, concerned police station. And the court has passed an order with regard to the fact that it will not be handed over. Now that has also been violated because the order, if your Lordship kindly say page number 38, the Jimmadar shall not dispose of the seized vehicle. Now it has already been disposed of. It has been given on auction to a certain other person, because the specific direction is there on page number 38, and that has never been mentioned with regard to the fact that after this order has been passed, whether they have accepted they have recovered the vehicle from the person to whom it has been sold on auction. So there is apparent illegality on the part of the learned trial court in passing this particular order, Lordship, because the law is very clear. When this vehicle is to be lifted, there should be some sort of default on the part of the person who has taken this particular vehicle on loan. Now here in this case, the accrued amount was 4 lakh something and the petitioner has paid more than the accrued amount. So there is no apparent default on the part of the petition. Now how it has been lifted and how this trial court came to a finding that it will be in the safe custody to hand it over to the Tata Finance. There is no finding with regard to that. In absence of any finding, this particular judgment, this order is perverse, Lordship. So this is the submission on my part, Lordship.
I'm waiting for response number 2, Your Lordship. So far the FIR is concerned, Your Lordship, the police has submitted the final report in this case. So whatever allegation that has been made in the FIR, that has been nullified, Your Lordship. It is there in the LCR, Your Lordship. And regarding the Jimma of the vehicle is concerned, the lower court below has rightly given the safe custody to the respondent number 2. Because here whatever the petitioner has defaulted in payment of the EMIs. It is not that they have not been informed about it. Notice was issued, and thereafter also the petitioner never bothered to pay the EMIs. Then loan refund notice was also there. That also was not been complied with. Then only after that only the respondent, they have gone for arbitration. And in the arbitration, under section 17 of the Arbitration and Conciliation Act, or whatever it is so passed in arbitration proceeding so the petitioner took back the peaceful possession of the vehicle. And this is not that whatever the petitioner has said that without information or without his knowledge the vehicle was taken. It is totally wrong, Your Lordship. Even before seizing taking repossession of the vehicle, the repossession intimation was also given to the police. Post position intimation was not given. Then only after that only the vehicle was repossessed, Your Lordship. And
have you filed any notice to him?
yes, Your Lordship. If required, I will produce on the next day, Your Lordship. That is there. And so far the FIR is concerned, it has been closed, Your Lordship. There is nothing in the FIR. So whatever allegation is there, it is nullified, Your Lordship. And so far the possession is concerned, custody of the vehicle is concerned, the court has rightfully given to us. And if Your Lordship may kindly...
At present, the FIR on the basis of which the case was raised is not I mean, it is already been ended in FIR.
FIR, Your Lord. It is there in the LCR, Your Lordship. You may kindly
So
put it.
your case is not there.
I have to open that instruction, Lordship.
And even the petitioner was also informed about the FIR, Your Lordship. It is
I
in
have
the,
to
in the
open the
month
instruction
of
with
June,
regard to the fact whether
it is
any
in the
objection
month
has been
of-
filed with regard to the
It is
FIR
in
or
the
not.
month of June 2023, the FIR was submitted, Your Lordship. So it is now almost 1 year now.
I am basically on the finding of the Lanet Trial Code because the Lanet Trial Code at page number
Just nothing, sir.
38, page number 38 made a specific statement that there is no
No, but the question
This
is that
with
you
regard
have
to
a
the ownership.
conviction or you are coming before this court against the order of 1906 which was passed in connection with that case. But
Yes,
the
yes.
case is not in existence.
No, not with regard to that case, Lordship. Here this application was filed because the vehicle was seized pursuant to the
Application was
FIR.
filed before the Lanet court is connected with that case.
That-
only.
that
so
FIR.
if the case is not in existence, so you take instruction if you
I
want.
will take the instruction, Lordship. Any day in the next week, Lordship.
Major may be listed. Otherwise, as per you, the FIR is available in the case
Yes,
record. But do you have any instruction that the notice was also served to the...
Regarding that, I will take instruction. If there is any document is there, I will produce it.
By- If that the position is not be continued further, so we fix a date.
Yes, Lordship. Date can be fixed, Lordship.
10, 12C. We are fixing it on 12C. Will it be possible on 12C?
12, no, Your Lord. There may be some other date after 12.
After 12.
Yes.
13, 14?
Yes.
14? This one.
Oblige.
Oblige, Lordship.
Yep. My lord, they have married, my lord, joint petition by the boy and the girl. Additional affidavit I have filed and I have brought on record the marriage certificate. Page number 26 of the additional affidavit will my lord mention. And both of them have filed this joint petition for quashing of this FIR.
20? Additional
26, additional affidavit, running page 26.
petition is the joint petition.
Yes, this is a joint petition.
Petitioner number 1 is the victim, my lord.
Petition number 1 is the victim. Now, not victim, my lord, now my wife, my lord.
This is the POXO man.
And my lord, these things are not.
POXO.
In 164 and 161 fully implicated, my lord. These are case of perjury, my lord.
Perjury?
And 161 statements are in more details, my lord. Much more longer than
But
this
I
one.
don't want to prosecute my wife for perjury. Now they are living happily, my lord. Both are major as
You
on
need
date.
not prosecute. The court may prosecute. Why should you prosecute?
195 CRPC.
On what you have made statements before the court?
The old
Every alternate day we are coming across such type of things. Police are made run after these cases.
That is why, my lord, nowadays for 354, but initially when 354 was enacted, my lord, same thing happened, my lord. All husbands are filing anticipatory bail. Nowadays, Arnesh Kumar came. Probably for POSCO also something will come, my lord.
May come.
I am sure, my lord, within next 5-6 because POSCO and all these cases are being used also nowadays, my lord. Love affair, voluntarily they indulge in some relationship and then POSCO. And the boy's career is gone. One similar order, my lord, order I can rely, my lord, passed by this court. Where taking into account the other judgments of the Supreme Court, our High Court's judgment. That is also 376.
For 376, there are some certain like Kapil Gupta and all. That is there. But talk to it.
POSCO, my lord, she was 17 years, 9 months. When the FIR was lost, she was already major. Now she is super major, my lord.
Maybe for many.
Let them live happily, my lord.
The question is, the matter be, I won't pass any order because I passed 3 orders regarding POCTO, wherein the petition for watching was rejected by. I don't want to pass any order on POCTO. 376 allowed some. It's a bit different from the POCTO effect. So POCTO, I have rejected also. I don't want to pass any order in this case. Better I'll fix it at the beginning. So that
Before any other bench you are fixing?
so that kind of order I won't pass because it should not be there. Because, what that kind of order that I'm saying. Because the statement, to go by the statement is very, or the allegations that will be made in the statement. She was not even 18 at that time. She got her pregnancy got aborted. So these things are there. Just simply it will be listed. It can be. It will be listed on 50. Before and most probably it will be listed in any other bench because I'll not be here. That's why I'm just not.
Outline
because
benches.
in my opinion, my view is a bit different. Maybe you may be affected by that. I have already rejected. So I don't want to pass.
I am obliged.
It will be on 5th. Okay.
Oh, my lord, barring 5th, barring 5th, 5th, 6th, 7th, my lord, I'll be in Arunachal.
10.
I'm obliged.
May I be before Lordship? My Lord, regarding Zima, my Lord, of a vehicle, my Lord. My Lord, before the emptying order, my Lord, I'll just take your Lordship kind.
Dima only. Dima.
Yes, my Lord.
Case diary, I think the copy of case record was called. Today we don't have it.
We need the LCR.
That was already called perhaps on 20th of April. Not received.
My Lord, if Lordship may kindly be take up the matter, my Lord, because the vehicle has been, my Lord, almost 2.5 years lying in the police station, my Lord. That was the now present condition.
Now that it is charge sheeted and all, perhaps
Yes, my Lord.
no longer required in the. But is it a NDPS case?
No, my Lord.
NDPS.
No, my lord. It's 378. Of course, otherwise, my lord, 378. I told my lord in my respect for submission, I'll satisfy your lordship.
No,
It will
I'm
not
not
attract.
here.
It is theft, my lord.
379.
379, my lord. And section 52 is there, my lord,
So why
regarding
don't
lake.
you approach the learned trial court below, because the court
Three-
that
three
it
occasion-
will be the best court. I think.
Three occasion I have
That
approached,
was
my lord.
rejected.
That's why lordship on
All
last
the
occasion.
petitions are rejected.
Yes, my lord.
Then obviously the LCR has to be there.
Since there is already an order, so let the LCR move.
Otherwise, my lord, record shows that, my lord, everything was purchased through auction, my lord. It's a, my lord, foreman of my lord.
Was the auction is also it was conducted genuinely, or is
No, my lord, it is not dispute, my lord.
it's not?
That was not the dispute. Only thing lower court rejected was that, my lord, my lord, this or that way, rightly or wrongly, I have registered the case, registered the vehicle in my name when the vehicle was in, this case was pending. That was the first ground. And the second ground was that, my lord, the condition that was laid down in the auction, my lord, in that vehicle, that condition was, my lord, before that vehicle was, my lord, sale. That condition has not been fulfilled on my part. But that, anyway, that condition will not apply to me. That was my respectful submission. I will satisfy lordship if lordship is inclined to hear, my lord.
Scan copy of the case record was called for. What are you fixed?
My lord, any fixed it, my lord. Any fixed it.
Registry will bring, so perhaps.
Should we get fixed or after 2 weeks? After 2 weeks, I'll get.
Yes, my lord.
So June 14th.
13th of
13th.
I mobilize, my lord.
INE.
May it please, your lord. In this matter, I have been newly engaged, madam. Probably, madam.
He sought for time saying that
Yes.
as Suradit
Yes.
will.
Yes.
Now you are saying that you are newly engaged.
Yes. The thing is that probably, my lord, I have checked, my lord, the LCR as well as the notice to the victim.
Not yet.
Not complete.
POCSO.
In fact, order was not there.
Yes.
But that's the
Well, we'll take fresh steps, madam.
Huh? Yes.
We'll take fresh.
Fresh steps in a sense, no steps taken. Oh, just a second. In INI. In fact, 90 is for suspension of sentence.
Yes.
What is it? 90?
The
IA, suspension of sentence.
Oh, I
One small prayer, man. My name is also shown as a counsel for the respondent number 2, man. That may be Starko, man. Perhaps they are in the cause list.
Pardon? What is the name of the body?
Right.
From okay.
Highly obliged.
In this case, service is complete because after email, paper publication was there, my lord, in the month of
You have
March.
already filed your affidavit.
Yes. So already this honorable court has held that service is complete.
Already held.
Yes.
In which order it has been held?
My lord, it was Honorable Justice, my lord, M. Ali, perhaps, my lord.
Justice Sam Ali had passed the order for circulation of notice in the newspaper.
Yes. And
That was there, and thereafter one order is there on 5/4/2021 regarding the filing of the affidavit. But regarding
Okay.
service, under which process we have taken earlier?
My lord, earlier, my lord, we have issued a register steps, my lord, that thereafter paper publication was there, and we have filed our affidavit on 30th of March 21. So, my lord, Lordship may kindly observe that the service is complete, and Lordship may fix it on fix for hearing.
It is a NI.
Yes, NI case appeal against acquittal.
So it does not be necessary because they are acquitted.
But my lord, he is avoiding now. And he is here. He has a shop in Godasguri.
But your address you have given? Shobha Market, Ganesh.
Yes.
Earlier, what kind of report was submitted by the process server or the
Notice perhaps not returned.
notice not?
Perhaps. So far I
Just do
remember.
one thing, because it is the NI case and that is what we have come against the acquittal. So definitely the person may be affected. If the your appeal is allowed.
In that case, Lordship may engage my lord, amicus curiae also or legal aid counsel, because my lord, he is not my lord contesting, because he is evading my lord, evading the process. Yes. Dishwar police station.
One thing or one is be appointment of
And now, my lord, now I am also not aware whether that is a knitting, my lord, or knitting shop. Whether it is still there or not, I am also not aware. And my connection with the client also, my lord, because case is pending since long. My connection is also, my lord.
the appeal is of 2017.
Yes.
But it was not come up only once after 2021 order was there. Then after 21.
That is why paper publication was directed. And service is complete to that
Is
effect.
okay, but the only one report was awaited. Now, see, as per office note dated 27/8/2019, you have not taken state. Then on then on 22/9/19, you both shows that you have taken state. Then call for this record. Then again, in 21/20, you have not taken any state. Notice by paper publication was there. So it's not the case that we have taken 3 times state, or it's not known. Rather, in once most probably have taken states. That too the report is not yet received by the
In the
registry.
trial court also, my lord, they were doing same things. NBW has issued, and during pendency they made some payments. Thereafter they issued check for a payment of the remaining amount. Check was dishonored. Then my lord, he did not appear. Ultimately acquitted, and we have filed this appeal. And he was earlier he was residing in a rented house. Now where he is residing, appellant is
No,
not
you have
able.
said this food, the Ganeshpuri.
Yes, shop was there at that time. So, shop was owned by her mother.
From the affidavit filed by the appellant, it seems that the paper, the notice was issued to paper public to widely circulated newspaper, and to that effect, the affidavit has also been filed. But from the result of the note of the that no, but considering the note of the nature of the case, I find that that notice may be print or may be equal to the respondent to it to the no, it will be not equal to the to concept necessary order what was after it was from concept. This time I'm going to pick the date because it is pending since 2017. So you take this to Dispur police station. If it is not, we'll pass the order. Effect order. Because 3 weeks minimum will be required, I think. 3 weeks of circular. Give a fixed date. 24/6 will be. I'll be there with them.
It is appeal filed by the victim for the enhancement of sentence imposed upon the
enhancement of
injured
sentence.
party. Enhancement of sentence. As per Lazimapur report, the service has been completed.
I'm appearing on behalf of respondent number 2 and 3.
If LCI received that maybe
Number 2 and 3. So services completed.
Yes.
if LCI received testimony fixed for hearing.
NCR we have not seen. No?
Okay, LCR has not been called.
Not been called for.
And LCR may be called for.
LCR may be called for.
Not received. Services complete. Maybe fixed for hearing after receipt of LCR.
T. Chakravarti.
Mr. and MS we call for the LCR based it. It's a 2020 patent, so immediately after LCR it will be gone.
Obliged.
May it please your Lordship. This is an appeal against Equitel Lordship, and the appellant before your Lordship is a financial institution Lordship. The appellant as complainant brought a proceeding under section 138 of the NI Act Lordship.
Leave is not yet granted.
There is a delay condonation
It is
petition.
not yet granted.
There is a IF for delay condonation, my lord. Today it is listed.
Oh, earlier I for delay control.
Yes, my lord.
How
IA number 573 is a
573 is the delay.
is delay in preferring leave Lordship.
Yes, yes. What was the delay?
Delay is 200 days in preferring the appeal.
200.
Yes, yes, sir.
Why such a long delay?
It is a financial institution Lordship. It has to take some concurrence from one office to another office. I have mentioned the delay Lordship, explained the delay at paragraph 8 of the petition Lordship.
Yes.
And in fact, my learned friend doesn't have any objection to the delay.
Lordship may record my formal objection. Lordship may condone delay.
So as per you, it was a financial institution. To observe some formalities, it took some time.
Yes, sir.
I had
RS Mr. Rahman.
February 100 or 200?
200.
100. Referring the petition court of therapy against therapy for preparing a appeal against as per judgment and order dated 21 by first by United States Administrative in annexed number 2012. Where I submitted further that the petitioner is a penalty and who as for filing the and for filing the petition for preparing an appeal against the order of Google. It took several months, it took 200 days to observe the form of it. The further submitted that this case has been well explained in the para of the presentation. The further submitted that there was no interference, negligence, or action on the part of the connected as connected with field against order of it. In this context, Mr. Ranet on the perspective, a response submitted that today is not well explained petition and there is no there is not really is not well explained and the ground is just not in ground convert considering the effect of and what the present in preparing the corrected for the application to prepare and speak against number for it is already numbered. No, it is already numbered. Just please take
with regard to
petition will be heard on the next day.
late petition, my lord.
Yeah.
Yes, my lord.
Now this is your disposed of on your delay is gone.
My lord.
Heliograph. Lordship has fixed the date after 15 of
For petition order. 2 weeks or
13 of June.
30th of June. Okay.
To indicate this is a state appeal against equitable lordship, I tender my apology. On the last occasion, lordship has ordered us to take fresh steps, but it is not taken till date. Lordship will give me 2 days time. By tomorrow is a Saturday. By Monday, I'll take the steps. The leave petition is itself pending.
Substituted inadvertent this to the and debate for some more time. It is allowed to spread on the appellate 5 days.
Not
5
obliged.
No, it is appeal against acquittal. Leave is not yet granted. Here in this case, it is an NIA case, and check amount of rupees 1,93,000. And accordingly, 4 numbers of exhibit was exhibited. That is the check return memo, cleared notice, and exhibit 4. And accordingly, PWs has been cross-examined, and DWs also been cross-examined. Judgment was pronounced. On the day of judgment, the complainant realized that one postal receipt, that is exhibit 4, that is of dated 11/3/2014, instead of that postal receipt, 23/4/2014 postal receipt has been exhibited. Though at the time
The
of
postal receipt looks to be of
11/3/2014.
or
And
it is wrongly
wrongly exhibited as 24/3/2014, because another case, some other cases between the parties also there, and wrongly 24/3/2014. That has been wrongly exhibited. Though it has been annexed at the time of filing of the case 11/3, but at the time of filing evidence in affidavit 11/3/2014, the postal receipt not been exhibited. Instead of that, 24/3/2014. On the day of judgment, the petitioner has filed the petition with regard to the fact that wrongly posting or wrongly exhibiting the document, and that petition has been in the appeal memo, Your Honor. Go through the appeal memo.
appeal memo in page number.
This is on page number 33 here.
This was the petition.
This was page number 33, annexure 6. May I read it here? That the complainant begs to state that the complainant annexed a postal receipt 11/3/2014 as annexure 4 in the complaint case. The complainant states that filed an evidence in affidavit along with some documents before this honorable court, and those documents were marked as Exhibit 1, Exhibit 2, Exhibit 3, 3.1 and Exhibit 4. The complainant by bona fide mistake exhibited the postal receipt dated 24/3/2000 instead of postal receipt 11/3/2014, and in his evidence in affidavit as Exhibit 4. The said postal receipt dated 24/3/2014, which marked as exhibit, is not connected with the case, and the Exhibit 4 postal receipt 24/3 ought to be postal receipt dated 11/3/2014. That the complainant said the honorable court was pleased to take cognizance of this case after verifying the annexed document of the complaint case, including the annexure 4. At the time of filing of the case, that document 11/3/2004 was there, and accordingly cognizance was taken, but wrongly, bona fide mistake on behalf of the council, the postal receipt of 24/3/2014 was accepted, and accordingly on the date of judgment, this petition was filed. So that with a prayer to allow the complainant to adduce additional evidence to prove the postal receipt 11/3/2014. And that petition was rejected and judgment was pronounced. So against that, and the order was passed on 11/2/2022. It is in annexure 8 here, page number 37. And it was rejected. So my humble prayer is that this he may be allowed, this leave may be granted, and the record may be sent back so that he can exhibit those documents and test doesn't make it. That is prayer in the appeal.
This is
And even just in the cross examination also they have not put any question on that.
But in spite of getting 30 opportunities, 30 days were passed, he did not rectify, my lord. On the day of judgment, and a petition was filed, my lord. And that petition was rejected, my lord, because 30 opportunities he got, he did not rectify, my lord, intentionally, my lord. I don't know why he did not rectify. Only on the day of judgment, he woke up, my lord, and then filed a petition, my lord, for rectification. And on that basis, my lord, his section 38B clause, my lord, that was violated, my lord. Beyond 130 days, it was notice was given beyond 30 days, my lord. Only on that ground, my lord, this petition has been rejected, my lord. Only on that ground, my lord. This section 138B has been violated. The 30 days notice was not there. 43 days were there. On the basis of Supreme Court judgment, my lord, Kamaleswaran Kumar, that on the basis of that, my lord, it was dismissed, my lord. So, my humble submission, this petition should not be allowed, my lord.
Ma'am, please. That 30 days, that beyond the reasonable period time, that was considered on the previous postal receipt. 20, not 11-3. Not 11. There's bona fide mistake on the part of the 11-3 2014 postal is very much there with the later on he has exhibited it wrongly. Not intentional. Accordingly, file the petition so that it can be corrected and by further giving evidence. Yeah. D. Chakraborty.
I filed objection that is recorded, man. I filed objection also, man. Recorded.
Hello.
They were supposed to file objection. They have not filed their objection to the leave petition.
I could not be communicated with the client, my lord. Therefore,
You need some more time or what?
1 week or 2 weeks.
1 week?
2 weeks.
Hard Mr. NPP regarded
Carefully. Carefully.
Carefully, put it upon. It is submitted so that inadvertently could not conflict client and could not prepare the object. What the big support please keep it recording. Do we?
Yes.
Please keep it recording. And I think the conflict.
All right.
Right.
Lordship, objection have been filed in the
I filed.
Objection?
As far as 389.
Regarding service on respondent number 2 was the office note is there. That is,
You have filed your
Yes, yes. We have filed our objection, but this is a POXO matter. Again, the victim needs to be heard.
what is the report of the I mean the
Otherwise, we don't have any report.
office note says that it has been that AD card is returned. The flagged office note.
no certificate. Take it to no certificate. Master section has probability notice. It's not returned to the consulting.
Now that is, it is a POXO matter. They have to take notice as per Deepak Nayak's case.
I will again serve the notice.
By during that time, perhaps Deepak Nayak case had not come. Now, Lordship, they have to serve the copy upon the registry, and registry will do the needful. It will be routed through our office. Registry will give it to us.
Only on respondent number 2.
Perfect nahi victim of perfect.
SS Borba.
SS Borba.
Artist SS Borba. Notes of it should be raised,
Huh. They will give it to the registry will give it to us, and then we will route it through officer in charge.
It will be routed through your office.
Yes.
It's about your petitioner is in jail.
Yes.
It's legal aid counsel.
I'm legally counsel.
You are legally counsel. How do you come? Okay, let us see what.
My lord, in this matter, LCR has been received. Kindly listed for hearing.
I'm appearing for the respondent. When?
So, we have received. That's it. Pardon?
N. Ahmed.
When?
Is it admitted? Otherwise?
Not yet admitted,
Not
maybe.
yet admitted.
Yes.
After the metro of 2022.
Yeah, after summer vacation. Problem. Yeah, please.
Although my learned friend has filed one objection petition in the delay condonation application, Lordship, the copy has not been served.
We will serve copy, my lord.
What was the delay?
That is, it is 237 days.
Some issues are there, my lord, so perhaps objection will be required so that it can be heard.
Lordship, let them furnish the copy.
We'll furnish copy, my lord. We'll furnish today itself, my lord.
And thereafter, Lordship, after a week.
After a week or 2 weeks, my lord, may pick it.
Your response number 6, no?
226, my lord.
Yeah, do this.
The respondent number. You have received the copy of it from it's after 2 weeks. You need any picture or it will be listed
After 2 weeks, my lord, we'll serve in the water.
May I please the Lordship? Lordship, office note dated 2/5/24 shows that the service is awaited upon the respondent, Lordship. Lordship.
as per office note 5
Deployed.
Washing of the FIR and the charge sheet and the entire proceeding. Counsel is not there. The B coupon. Pass over the matter.
It will list it up.
May I please your lordship? Lordship, my senior is in another court, so kindly the matter may be fixed at 2.
Otherwise, many matters are fixed at 2 in fact, so it may not be possible. I don't know. At which age I cannot say. By the way, what is the issue? It is in order
The
column.
main issue is, my lord, it's a yes, I for the bail.
I is for the bail.
Yes, my lord.
If
And
it
he had,
reaches, then if it doesn't.
my lord, may the matter may be fixed at 2 o'clock.
That's what we are saying. Already 2-3 matters are fixed at 2. So your matter may not reach out. That I cannot say because hearing matter is also fixed at 2.
Then, my lord, for time being for Passover.
Huh?
For Passover.
Within 10 minutes, your dinner will come. Passover. It's up to you. Passover is for Passover. For time being, it cannot be. I'm saying that if time permits, we'll do after 2. There are 3 matters are there in 2 at 2. One is hearing also. It may take some time. So I don't know. If it reaches, then it's okay. Let it be for time being.
I'll call.
Whatever you can do.
May I please your lordship?
Yes.
Whether lordship would take up the matter or not?
Oh, acha.
Because third,
Huh?
lordship's order has been challenged in this.
Oh, acha. Oh, I just definitely I cannot take. 37.
At page 30, my lord.
30.
30.
Oh. What against the what's the criminal petition?
My lord.
Against the framing of
Framing of charge, my lord.
charge. You have come.
Yes.
What any after 1 week after 1 week it's for after 1
Obliged.
Nine is also IA. 39 is also IA. Most
There
it
is
also for
IA.
suspension of sentence.
NDPS for 10 years.
Have you filed your objection there?
Yes. Yes, we have filed our objection.
You have filed your objection. Non-application for 40 cap. Now, how many matters are
34 and 40 and 35.
34, 40 and 35. So we'll take up first 34, then hearing, and then let us.
And just my lord, compilation just about the positions part. The compilation I have given my lord. What I find my lord.
Right, compulsion. We have received the.
Yes,
HR.
that is also there, my lord. Just for the convenience of that, yeah.
Okay.
To save times, my lord. I have. Now, whole thing I find, my lord, just I take, my lord. This allegation is that after 3 days, father filed a case saying that my daughter was coming from the school. On the way that he has taken him to his house by motorbike, my lord. Instead of coming to her house, and both the houses are only 3 houses away from each other, my lord. You go to one side this house, other side that house, my lord. It is in the evidence, my lord. Now, allegation is that, my lord, she is...
Took the girl to his own house.
Yes, his own house. This is the allegation as per FIR, my lord. And there he...
Near to the house of the informant.
Accused.
informant house and this house is only 3 houses, my lord, that difference, my distance, my. And from the victim state, it comes from this side, accused house, and other side of the road is that victim's house, my. Now the allegation is that taken, and ultimately, my lord, on the same night, it is also in the evidence, Gaubura was reported, my parents have gone there, saying that she has come to my house, you take her to, you hand her back to the guardian. So ultimately he came, it was handed over to the guardian, my lord. So there is no question of rape, my lord, because in the same day, my lord, the information got, and same day she was handed over, it is also there, my lord. When one page it comes, the next day she was handed over, my lord. These 2 versions are there from the 2 openings that you also will see. So our case, doctor did not find anything, any assault or anything, my lord, doctor did not find. So on the film, the husband that is the, my lord, the accused, he has also adduced evidence, SDW1. His case is that he was not there and he was at Guwahati. He was not there in his house. Marriage was, my lord, talk was going on. They wanted to give her marriage to me, with me, since she is minor. So, my lord, I also refused, and I also live at Guwahati. I am also not so much of solvent, my lord. So that's why marriage was, but they were actually interested to give marriage to me. And accordingly, she herself came to my house. My parents have gone to the Gaubura, saying that she has come and she refused to go. So Gaubura came, and ultimately a bichar also held. Thereafter, she was handed over. In between, there is an allegation come, my lord, this petitioner has raped her. This is the case. Now I take to your lordship to PW. One is the informant. Page your lordship in the compilation, page 11 your lordship. Page 11 in the compilation. The file after 3 days, man. Yes. My page 11 you will also will find. I just middle portion I recommend. My lord, Steve, I am the informant. I know the accused person Saddam Hussein standing in the dock. Victim Almina Begum is my daughter. She is aged 16 years now and date of birth is so and so. At the time of incident, my daughter was studying in so and so. Incident took place about 3 years ago. On the day of incident, my daughter went to school and thereafter she did not return. I searched for her but did not find her. On that day, I came to know from a person named Thaiju that my daughter is in the house of the accused. So on that day, he himself got them. On that day, I sought a bichar as my daughter was taken away by the accused. Accordingly, on the next day, a bichar was held at my elder brother Nurul Hussain house, but the same did not yield any result. As a result, villagers recovered my daughter from the house of the accused and thereafter handed back to me. 3 days thereafter incident, I lost the Azhar. Now come to my kindly come to the next page, my cross my. I do not know English. I cannot spell the English word of rape. The house of the accused is situated 3 houses away. Your lordship, 3 houses away from my house. If my child or minor child has gone somewhere, it is my duty to find out where. If I know that it is there, I could have gone there, had it been a true, my lord, actually it is correct, my. So the house of Chanmia and Taju is situated between my house and the house of the accused. They have not been examined. I have not mentioned the date of birth of my daughter in my Azhar. I am skipping that, my lord, because I am not about that, my lord. My daughter used to commute to her, your lordship. I am reading, my daughter, your lordship will find. My daughter used to commute to her school on her own. My daughter told me that she was kidnapped near from a mosque and that there was a residential houses near the mosque. I cannot say whose house is situated near the mosque. Zakir, Shamsul, Jahangir and Gaubura Nugamin, PW3, he is a very important. Gaubura went to the house of the accused and recovered my daughter. I did not stay before the IO that I heard from a person named Tajin. It is not a fact that my daughter never told me that my daughter told him that the accused on the pretext of dropping her at the home took her away to his house in a motorcycle. It is not a fact that I had lost the false case against the accused to extract money from him. It is not a fact that my daughter was not kidnapped by the accused and that I had lost the false case only to harass him. Now important, my lord, your lordship kindly see. PW2 I am just skipping. Yes, PW2 my lord victim. Page 13, next page, man. My lord, learn to come page 14, my lord. Cross. I know the date of my birth. My school is at a distance of 20 minutes walking distance from my home. 20 minutes only distance. The house of the accused is 2 houses away. Father said 3 houses. She said 2 houses away from our house, and the house of the accused is on the other side of the road from our house. This side, their house, other side the accused house. She is saying, well, I was alone when I was on my way to home. At the time of taking me away by the accused away, nobody has seen. I cannot say as to how many family members are there in the house of the accused. The family members of the accused came to know about the incident after 6 p.m. on the day of the incident. At 2:30 occurrence took place. And gone to the house, and family members certainly could have known in immediately, my lord. It is a village, my lord. It is not that, my lord, building somebody in the first floor or third floor that they cannot know it, my lord. So saying that only about the incident after 6 p.m. on the day, the family members of the accused did not offer food to me on the night. I resisted the accused when he assaulted me sexually. I sustained scratch injury on my hand at the time when the accused forced him upon me. Police did not seize any clothes. When the accused took me inside his home, I did not raise any hue and cry. I raised a hue and cry on the next morning. And hearing my cry, mother of the accused came to inquire me. Now your kind of very important is PW3, Gaubura. Very important. Your loss page 15. Next. PW3, my. Your loss got it. I know the informant of this case. I know the accused person, Saddam Hussein, standing in the dock. Victim is the daughter of the informant. The incident took place about 3 years ago. On the day of the incident, at about 8:30 p.m., accused Saddam Hussein's brother, that is my brother. My brothers, along with his family members and many other villager people, came to my residence. My family members has gone to the Gaubura's residence and told me that the informant daughter had come to their house and that I should come along with them to their house. Accordingly, I went to Saddam Hussein's house and found the informant daughter there. On being asked, informant daughter told me that she is having a love relationship with the accused Saddam. In this connection, a village vichar took place in which many people participated. Both the parties were directed to enter into an agreement to the effect that marriage between the accused Saddam Hussein and the informant daughter would be solemnized once the informant daughter attains marriageable age. She was minor at that time. So that was the vichar. The informant daughter was handed over to the informants after the village meeting on the said day. Said day, on the day of occurrence. It is independent who is saying that. Later I came to know that the informant has lost the Azhar. So there are no, in the meantime some money was demanded, that was not paid. So Gabu was saying that later when I came to know that they lost the Azhar against the accused, but I do not know why the Azhar was lost and when exactly it was lost. Then he says, on that day I did not meet Saddam Hussein. He was not at home, my lord. He was at Guwahati. He also, my lord, any evidence, my. So this I am relying on the evidence of PW3 basically, my. It shows that there is a love relationship. She on her own has gone there, my lord, in absence of parents have gone to the Gaubura house. They requested the Gaubura, you come here and take her and hand over to the guardian. Accordingly, she was, agreement took place. All marriage will be taken place after the attaining the majority. Then, now, Hogue also made an independent witness. Hogue, 16, next page out. He is also saying, my lord, I along a middle portion I am reading, a little later, I along with many other persons, including Gaubugan, went to the house of the accused and found the victim girl there. After that, I left the place. On the next day, I again went to the house of the informant and came to know that the family members of the accused did not accept the victim girl. She wanted to remain there, my lord. We did not accept, our family members did not accept. And the girl thereafter left the place of the accused and started staying in the house of the informant. Police did not question me regarding so and so. It is not a fact that I did not visit the house of the accused along with many other people, including the Garuba, and that I also did not find the victim in the house of the accused. Then 5 is the next, my lord. Independent. Also nothing, my lord, only that staying. Victim is the daughter of so and so. Incident took place. I cannot exactly say the name of the victim guard. I did not state before the police. It helps none, my lord. Now come to my lord, Dr. Feinman. Page 18, PW6. An opinion of doctor is, my lord, page 20. Page 19 bottom. Page 19 bottom. Opinion. On the basis of physical examination, laboratory, radiological investigation done, I am of the opinion that there is no recent sign of so-and-so, but victim exposed to so-and-so previously. There is no sign of injury on the victim's body at all. Victim's age is 14 years, 16 years at the time of the examination. Medical report sign. So, taking into consideration the medical report, along with that, my lord, however, evidence, I find my subject of your worship, my lord, point says, in effect, nothing, no physical assault, nothing taken place. Now, DW1, you look at what is my stand. DW1, your lordship will find the page 23. My aspect is I was not there at all. I was at Guwahati. She or her own has gone to my house. And the rape part is also, it is also belied by the doctor's report, my that part. Even not a single injury, not a scratch also was found there. Now page 23, your lordship. DW1 is the appellant one. The instant case was lodged against me by the informants on the allegation that I have kidnapped his minor daughter. The Ejhar was lodged against me in the year 19. Informant has lodged a false case against me. The informant forcibly tried to get his daughter married with me. Your lordship, this is the whole case, man. Informants forcibly tried to get his daughter married with me. And one day when I was at Guwahati, the informant brought his daughter to my house with a view to get her married, but our parents refused to accept her. On the very same day, Shamsul Haq and Malik came to our house and demanded rupees 7 lakhs if the marriage of the victim girl is not accepted by our parents. Middlemen come in between, my money part comes, man. My parents refused to accept proposal brought by Shamsul Haq and Malik. The informant later lodged the Ejhar against me. I came to know about the incident from my parents. It is not a fact that I had kidnapped the victim girl while the victim girl was on her way to school, and thereafter I confined her in a room and committed so and so, so and so. It is not a fact that Shamsul and Malik did not visit my house. So my case is, my lord, it is normally up to 7 years. Normally it is considered, my lord, bail. On the face of it, there is a case of acquittal, my lord, subject balance is there, my lord. It is not a case of, my lord, conviction on the face of it. There may be either way, my lord. So on the face of it, I pay your lordship, my lord, his bail may be granted. In the meantime, trial, whatever may come, my lord, you will face the, my lord, consequence, my lord. Because my whole case, I was not there. So the question of bail also does not come. And it is also prove that doctor also, my lord. Whole story is not believable, my lord. Nearby house, this side and that side.
Yes.
So, my lord.
Lordship, here is the PW2. PW2 is the victim, Lordship. So here, in her deposition, the victim clearly states about the incident, Lordship. And it is like that, only that the relevant part. While I know the accused person, so and so, the incident took place in the year 2019. At the time of incident, I was studying at class 7. On the day of incident at about 2:30 p.m., I was returning home from school. While I reached Palhaji Ansolik Masjid, the accused came in a bike and told me that he would drop me at my house. The accused, instead of dropping me at home, took me to his house and confined me at home. I tried to raise a hue and cry, but the accused
prevented me from raising hue and cry. I got scared and remaining quiet. The accused then committed bad act with me about 6 p.m. By bad act means that the next day the accused locked me inside her. And Lordship, even in the cross-examination part, it is in the 14th number of page, internal page number 14. Here also, I was alone when I was on my way to home. At the time of taking me away by the accused away, nobody had seen. I cannot say as to how many family members are there. The family members of the accused came to know about the incident 6 p.m. on the day of incident. The family members of the accused did not offer food to me. I resisted the accused when assaulted me sexually. That was in the cross-examination. And now, Lordship, in the 164 statement also, the word is there, jur kori, tat aru loi gol, aru, it's not very much legible. Kemuk tat beya kam kore. The force was there mentioned in the 164 statement. So in the 164 statement and the deposition made by the victim as a PW2, it relates. And now, Lordship, the two independent witnesses, when they state, it is the PW4 and PW5, that their statement is like this. A little later, I, along with many other persons, including Gaon Buha, Noor Amin, went to the house of accused and found the victim girl there. After that, I left the place. Now, whenever they went there, in their statement, they found the victim in that place. That is in the PW4 and the PW4. Now only the matter is that when the deposition made by the Gaon Buha in this is a PW3, he said that there was a disagreement between them in this regard. But here, whenever the matter relates to 376 and the POCSO came, whether the force was there or not, and whether in that part whether C was there or not. So my submission is there. That is my submission. And in the part of the medical examination, in the medical examination part, in the opinion part, it is stated, though it is stated, the recent, there are no signs of this there, but there is, the thing is that there is previously is there. Maybe in some cases, the sign may not be there. We cannot say, but the statement of the victim is very clear. And whether it is 164 and the deposition made by in the time of cross-examination also, the force is there. So that is my humble comment. Okay, for the victim.
Lordship. First, Lordship, the girl is a minor, Lordship. She is 14 years old, as class 7 student. Secondly, Lordship, the medical evidence, the incident took place on 14/8/20, on 14/8, and the medical was done in between 20 to 22. So if medical evidence is 20, so recent injury was not there, but it was done after 8 days. So it is not that there was no sign. What is the evidence of the doctor is that previously there was some physical relationship with the girl. As the examination was done after 8 days, almost 8 days, 7-8 days, Lordship. So that is possible, Lordship. There is no recent sign of sexual intercourse, but victim exposed to sexual intercourse previously. So the medical was done after 7-8 days. So that is very much there that previously there was sexual intercourse, Lordship. And the fact that she had some love affair with that also, Lordship, but she is a minor, Lordship. Whether that has to be considered. And thirdly, Lordship, my learned senior is saying that the accused was not at home. If Lordship had gone through the evidence of DW1, so Lordship may kindly, I am reading DW2. Whether it was there in the compilation, I don't know, but I... Lordship, may I kindly read? The incident took...
Page 25, my DW.
Incident took place on 14/8, Lordship. And here I am reading DW2. I know the informant as well as the accused of the case. The incident took place in the year 2019. Accused is my neighbor. On 17/8/2019, informant took his daughter to the house of the accused with a view to marry of his daughter with the accused. Accused was at Guwahati at that time. So incident took place on 14. 15, he might have fled away, Lordship. And his family members might have told him to go there. And 17, the accused was not there. So whether he was present on 14 or 15 or not, that is not there. It was only on 17, after coming to know about the incident, the father of the daughter took her to his house. Then the parents of the accused refused to accept. And the fact that he was not there, it was only on 17. But it doesn't mean that he was not present on 14 or 15 also. If we go by DW2, Lordship, then the evidence of DW4 that he was not there, that is possibly on 17, Lordship. And the incident took place on 14. So 15, 16, 2 days he may be left that place, Lordship. So 17 he was not there. It doesn't mean that he had not committed the offense, Lordship. And initially the girl was taken to somewhere else. Then she was taken to his house, Lordship. And the girl is very much corroborating her evidence in both in chief and in her 164 statement also, Lordship. And there is her school register also that she is a minor. So those things are there, Lordship. So at this stage, Lordship, if bail is granted, then possibly it will not appropriate because seeing all those conditions come. So that's my...
Basic question, my lord. My learned friend is saying on 17. 14 occurrence took place. 17, DW2 is saying 17 they have gone to our family. Gave a proposal for marriage. We refused. So 14 in the course also they have not put this question to DW1 also. He was not there. The whole question is, my lord, taking the girl in the house, whether I ever taken on, she was found because she has gone there. Gabua's statement is very clear, my lord, she was there. She on her own has gone there because she wanted to get married. Family also, maybe that family has sent her or family might have taken her, my lord. So my prayer is, but since it is a question pending appeal, my lord, there is no chance of immediate hearing also, my lord. Already 9 months gone, my lord. Local person, 7 years, my lord. Normally, this court, Madam President, for my experience, Madam, 45 years or something, Madam. Normally, my above, 10 years, 5 to 7 years, normally it is allowed. If there is a person. So, balance is there, Madam. Maybe there may be case of acquittal, may not be. But prima facie, I find a chance of acquittal. So, case may be considered he is a local person. Nothing will happen, Madam. He has never misused the bail also, Madam. Never misused it. All along he was on bail.
Amicus for the respondent number 2.
When he
14/8/23.
President was delivered on
They were on 12/10/23. Month and a half. 9 month 21.
Emphasize one, and
1.1 is just in the minute she got married also.
Kampura was PW
Order 3.
PW 1 what is problem and out the part and there are people out if it was her daughter was given by kept out despite not kept their daughter was kept out from had up from and from drug but that was as was or to the bank. That they and get there was Dr. as part of Dr. Fine, Mark of Edit, fine. Kind of report how find that it is export has been why he was in bail at the
Yes,
time
all
of
right.
trial.
Yes.
At the time of trial, he was bail. And he never justified. He became brought there in then became so when by people came but by and by instead of it also and it was admitted was the problem of not finding and the problem of not finding mark of defective on defective report of the problem of not mark of the another passed by that of some for the case number for
Obliged. I hear disposed.
Yes.
Additional session just come, a special just pops up.
No for that.
Okay, a special case number also name. Obliged to us.
Yes, open.
The issue is very minor issue, and gist of the case is that, and I am the owner. My house is connected by way of a path, my lord, which connects my house along with the other villagers. The private respondents, my lord, created an obstruction for which the ingress and egress of my family and other families have been affected. For which, my lord, 144 proceeding was brought, and which was, my lord, dismissed due to non-prosecution. And dismissed due to non-prosecution, my lord. However, my lord, the circle officer's report, the police report, are in my favor, and the reports reflected that they are creating an obstruction to blockage me, and they are trying to grab my path, and that path which I have already purchased from another person's path. This is the case, man.
So now what do you want?
So, may I read, my lord?
No, by the present petition, what will be the case of 482 or what? Is a petition under 482?
2482, my lord. I have filed my case, my lord, page 15, Annexure 1. Responded, my lord, notice served, my lord. They did not appear. So, my lord, it was served already.
There are 4 numbers. These are 145 proceedings, so they
133 proceedings.
133. So they are necessary party rather.
My lord,
Yes, they are more necessary than state, in fact. Because they are
notice served, my lord.
Notice
served, my lord. But they did not appear, my lord.
Imping orders are date 21 minutes.
notice will serve.
Notice served, my lord. They intentionally not appeared.
Seems to be duly served.
Earlier, my lord, by of usual process I have taken, they did not taken. Later I have taken 2 steps to officer in charge police station. Then it was served, my lord.
Nobody has filed.
It was served. So, my lord, my annexure.
They filed the petition. Petition was filed by the respondent.
No, my lord.
By you.
By you. First. Page 15. This is my first petition, 133. CRPC.
Page 15.
Yes, ma'am.
This is your petition before the executive magistrate.
Magistrate, ma'am.
And the proceeding was drawn up.
Proceeding was drawn up. Subsequently, my lord, they challenged before this High Court. They challenged respondents. But without issuing notice, the respondents, the dishonorable High Court passed order that after taking WS, that should be decided. Accordingly, my lord, the WS was not filed. But in one date, my lord, dramatically, the proceeding was stopped and it was dismissed. So, my lord, the issue was not decided, and my path is forcibly taken position by the under the position of the opposite parties. My lord, may I read? The first page, 15. That the below scheduled land is a part of the first party and other villagers connecting to the river Longai and then to the Ponarago so PW road and have been using, occupying and possessing the said land, said path since long back. It is to be mentioned here that the below scheduled land and path was originally owned by the Khairul Alam Chaudhary and subsequently his legal heirs named so and have been maintaining the right title interest and position thereon and using the public path running to the north and then eastern side towards river Longai. That the very dangerous and cunning and the greedy second party and their family members are with a view to grab the below scheduled public path, trying to create blockade, but the second party did not give any response to remove and set obstruction. In spite of repeated requests, rather they and their family members are now trying to create block the said path by erecting bamboo fencing or in any way. That the aforesaid public path is the only path to ingress and egress to the respective homestead, but the dangerous second party members are forcibly trying to create blockade the said path and to detain the first party and their family members, and for which there is a very apprehension of breach of peace and public tranquility in the locality, and considering all the facts and circumstances stated above, the first party petitioner have no alternative to come before this honorable court for relief and redresses. So, this 133 proceeding I have filed before the executive magistrate, and the executive magistrate, my lord, page 19, the first order I have passed. In enclosing here the original petition submitted by the complainant Kamal Hussain so-and-so, Mark Koringon, stating the second party member Manju Ahmed and others have been created obstruction to use the members noted and so-and-so. During local inquiry about the contents of the petition, it is found that both the petitioner 1 and 2 party members are residing in the same village side by side, in the dispute is going on with the regards to ownership of the below mentioned scheduled parkland, which is claimed by the second party members as their own land. But during local inquiry, it is found that the said path used by the first party since long. So this is the findings, my lord. Since long, and while the first party was working in Saudi Arabia for his job, that is me, my lord, from the year 2012 to 2018, and his father lying on the bed due to illness, then the second party members noted in column number 4 with the criminal intention to create an obstruction to the first party and also disturb them for moving to the below noted scheduled land, which is purchased by the complainant from the original owner, and also the second party members illegally made a water pump with a setup on trees in the side path. On the other hand, the first party produced one Xerox copy of the land deed in support of his ownership, but second party member could not produce any document and stated that if necessary they will produce their document to the honorable court. During inquiry, it is also found that the second party members noted in column number 4 are having a manpower and very desperate type of nature, and there is every chance to loss of human life and property of first party, or will be happened the assaulting incident by the second party members. So I beg to submit a proceeding under section 133 107 CRPC against second party members noted in column number 4. So I pray to before honorable court that a proceeding may be kindly be drawn up against the second party members
noted in column number under section 134, directing second party to remove the illegal construction nearby water pump from the below schedule, mentioned schedule, ingress and egress, and moving first party into their path. The first party will produce their witness during the time of trial before this honorable court. So, my lord, the first order it is finding
This report is submitted by the IO.
IO, my lord. Thereafter, my lord, page 20, my lord. Peruse the police report submitted by OC. The order is 2022-21. Peruse the police report submitted by OC Karimganj PS in connection with Karimganj PS non-FIR case number 25/21 under section 133 CRPC, including initial complaint petition submitted by Kamal Hussain, son of so-and-so Assam. Heard the land lawyer for the petition of the first party. On hearing, I am satisfied that there is an apprehension of serious breach of peace and disturbance of public tranquility in the locality, as the second party members have illegally created obstruction in the path as mentioned in the police report and complaint petition. Therefore, I, P.K. Gupta, additional district magistrate Karimganj, duly empowered by the GOP to hereby draw up a proceeding under section 133 CRPC. Ask OC Karimganj PS to remove the alleged obstruction from the said path and bring its original shape forth with the second party may file objection if any the next. So, well, there is a direction to the officer in charge to remove the obstruction on the basis of police report. Thereafter, my lord, the second party filed a revision petition before the learned session judge. And the learned session judge by order dated page 26, my lord. 31/7/2021, first order. Revision petitioners are absent. Opposite party number 2, that is me, represented by the Art Council. Judgment is prepared in separate sheet and tracked with the cross record. In view of the observation being made in the judgment, the instant revision petition stands dismissed. Send back the case to the land lower court. So, my lord, they approached before the session judge. That was also dismissed. Thereafter, my lord, page 27, kindly see, my lord, page 27. Thus, 133 proceedings that after dismissing.
So, where is the order of dismissal by this court?
By this court.
By this court.
By this court, my lord. That was page 35. Page 35. May I read, my lord? Page 36.
Page 35 is the order of this court.
Order of this court, my lord. The opposite party is approached before this court, my lord, earlier.
So that this division is also filed by the respondent.
That petition was filed.
This division is also the division for under 482.
482 filed by the respondent.
Filed by respondent.
Respondents, my lord, against the order of that, of the magistrate.
Against the order of dismissal.
Against the order of the magistrate.
Magistrate.
May I read, my lord, page 36. By filing this petition under section 482 CRPC, the petitioner has sought for quashing the order of revisional court dated 10/8/2021. That is the session judge order where it was dismissed, my lord. Passed by the Learned Additional District Judge Karimganj in case number 35/M/2021 under section 133 CRPC. The petitioner herein has contended that he has constructed a wall within his own premise, which he has purchased, and there is no such obstruction to the public road. But the trial court has passed the order for removal of the wall without proper appreciation. Heard Land Council for the petitioner and Land Council for the state respondent peruse the documents and the impugned order of the Land Trial Court as well as the revisional court. It reflects that the revisional court has upheld the order passed by the Land Trial Court. The Land Trial Court has passed the order on the basis of the police report. So, my lord, they failed in magistrate, they failed before the session judge, now they approach before High Court. The Land Council for the petitioner has drawn the attention on this court to the police report that has been submitted before the Land Trial Court. The police report reveals that the dispute is between the two parties to claim ownership over the disputed land by Annexure 2 of the police report. In paragraph 2 of the police report, it is stated as below. During local inquiry about the contents of the petition, it is found that both the first and second party members are residing in the same village, side by side, and the dispute is going on with regards to ownership of the below mentioned scheduled path, and which is claimed by the second party members as their own land. But during local inquiry, it is found that the said path used by the first party since long time, and while the first party was working in Saudi Arabia for his job from the year 2012 to 2018,
and his father lying on the bed due to illness, then the second party members not at in column number 4 with criminal intention created obstruction to the first party and also disturbed them for moving the below noted scheduled land which is purchased by the complainant from the original owner, and also the second party members illegally made a water pump with set up the trees to the said path. On the other hand, first party produced one Xerox copy of the said land in support of his ownership, but second party could not produce any documents and stated that if necessary they will produce their documents to the Honorable Court. During inquiry, it is also found that the second party members noted in column number 4 are having manpower and very desperate type of nature, and there is every chance to loss of human life and property of the first party, or will be happened the assaulting incident by the second party members. I beg to submit a proceeding under section 133/107 CRPC against the second party members noted in column number 4. On the basis of such police report, court has initiated proceeding under section 133 CRPC and passes order directing the second party to remove the obstruction which appears to be not appropriate. While the police report reveals only private dispute over the disputed land, in the petition filed by the respondent petition number in main paragraph 2 and 3, it alleges that the second party petitioner herein, and that is the respondent, their family members with a view to grab property tried to create blockade without giving response and has not disclosed the manner of obstruction. Both parties should have been given an opportunity to place their grievances. On the query being made, the Lands Council for the petitioner submitted that disputed construction has not been removed yet, and the petitioner has not submitted written statement before the trial court. None considering the nature of dispute by trial court may have the impact in entire proceeding, so same needs further consideration. Having regard to the grievances raised before this court and the stage of the case, petition is disposed at motion stage. At motion stage itself, with the direction to the petitioner to submit the written statement before the court annexing all his documents, and the land trial court will pass an appropriate order after hearing the land counsel for both the parties upon examining all the relevant documents. Impugned order dated 10/8/2021 passed over the Karimganj case number so-and-so, and the order of trial court is interfered accordingly. Petitioner is directed to submit WS before the land trial court within 3 weeks from today. Thereafter, my lord, kindly see page 39. The order submitted by the circle officer. Case number 35M2021. With reference to the subject cited above, I have the honor to inform you that in the above mentioned case number 35/M of 2021 under 133 CRPC, Kamal Hussain, son of so-and-so, Manju Ahmed so-and-so, after spot verification by the concerned alert staff of this case, it is found that the first party purchased land having DAG number 78. So, my lord, this is the circle officer's record. I have purchased the land. First party having DAG number 78, Paragana, Akbarpur, Moza, Nandanban from recorder Pattadar, and land is under possession of the first party. At the time of selling the land, the 8-foot breadth path was given. At the time of selling the land, 8-foot breadth path was given to first party. That is from the seller's boundary area to 8-foot breadth path is given for movements of local villagers to the bank of the Longai River. After same days, first party, that is Kamal Hussain, bought 1.5 justi, that is the 15 chowk of land from this path, but after that movement of some days, second party did objection to first party for movement in this path, and second party closed the path. Now there is no path from the first party's home for movement, no path, my lord. Movement to outside because that path is closed permanently by making a wall by the second party. Now, my lord, kindly see page 40, 13/6/2022 order, my lord. First party present with his land advocate filed Hazira and also submitted a prayer petition for remove the obstruction from path. On the other hand, second party present with his land advocate Hazira and submitted WS also submitted a copy of the order dated 23/5/2022 passed by the Honorable Fisher Justice Rumi Kumari Fukan of Guwahati High Court. In the order passed by the Honorable Guwahati High Court interfered the order of revisional court and order also the trial court dated 10/8/2021 in connection with case number so-and-so also has directed the petitioner to be filed the written statement within 3 weeks. I, being the ADM, Karimganj, duly honored the orders dated 23/5/2022 passed by the Honorable Guwahati High Court, do hereby vacate my previous orders dated 10/2021 as well as orders passed in 10/5/2021 or 20/25/22, and as per direction of the Honorable High Court asks both the party to appear before the before my court to submit required WS as per procedure. Now, my lord, next page 41, 25/7/2022. First party present file Hazira. Second party present submitted a prior petition for dropping the instant case. Directly dropping, my lord. The hearing should be done, but he filed a petition for dropping the case. Accordingly, my lord, page 43, the impugned order. 13/10/2022. First party absent without any steps. On the other hand, second party present file Hazira. Hard land advocate second party is on the petition submitted by the second party 25/7/2022 for maintainability of this proceeding. The land advocate of the second party argued that this proceeding is not maintainable in the eye of law, as the provision of section 133 CRBC does not attract in the facts and circumstances of the proceeding. Land advocate of second party also stated that as per provision of section 133 CRBC, if any single person affected, then there is a separate provisions for the land advocate of second party. Also stated that when public at large were affected, then the preview of section 133 came into force. The land advocate of the second party also stated that the subject matter of this case is purely civil one, and there is nothing in the record which incriminates that this case is quasi civil in nature. Peruse the case record and materials on the record as well as police report. On perusal of the record, I came into conclusion that it is true. It is in the case only one person filed this case, first party, and in my opinion, the provision of section 133 does not attract in this case, and the dispute between the parties seems to be civil in nature, hence the case is dropped. So, my lord, this is a clear case, not a case of mine. It is a case of all the villagers. I am directly affected, filed it. And that was, my lord, reflecting the report of the officer in charge, reflecting the report of the circle officer, and the honorable magistrate in earlier orders reflected that it is the path of the villagers. So 133 proceedings can be going on. There is no dispute on that. However, by the learned magistrate suddenly, on seeing this order of the honorable High Court, where the merit was not discussed, it was discussed that both the parties heard and accordingly. Now, without hearing, directly dropped the. So, my lord, I am confined in my home. My path is closed, and it is reflected by the order the officer in charge, the circle officers, and there is the court finding is that there is a path and path are purchased, and this path is for the villagers. So, in this case, my lord, before this lordship, my lord. If with this order, my lord, my small children cannot go to the school this rainy season at present stage, my lord. My client is continue calling me, what is going on?
In fact, the last order, what I see is he was not present and the court proceeded ex parte. Of course, in his petition, and the court said that only one party was affected, so no 133. And in his petition also, which he had filed before the district judge, the very first petition for proceeding under 133, he said that he was the only one who was affected.
No,
Now, in fact, page number, Lordship will see at page number 15. Page number 15 is his application. 15 he writes, the below scheduled land is the part of the first party and other villagers. He writes here, connecting to the river Longai and then to PWD road, and has been using, occupying and possessing the said path since long back. Again in his paragraph 3, he writes, that path is the only path to ingress and egress of their respective homestead, but the dangerous so-and-so had blocked. So the requirement of 130 is that the people should be affected. One part he writes that villagers were using it, and the other side he writes that only...
That villagers, my lord, it is reflected in the officer in charge report. That is the part of the villagers.
And officer in charge has also written that the land was not, the petitioners were somewhere else for long.
For long. So that was taken opportunity. Somewhere else means my family was not in somewhere. My family were there. For my livelihood, I was in Dubai. in 2012 to 2018. For that, my lord, as there is not a young man, so they are the very, my lord, dangerous persons. So they grabbed the part.
The
So
High
it
Court
is-
is not the fact-finding.
Yes, ma'am. High Court has not
So
gone to the
Lordship-
merit, my lord.
Lordship will again send it back. So that, because what I see, initially the case was fixed on 29-6. 29-6, both parties were present. 25-7, both parties were present. 5-9, both parties were present. 13-10, one party was absent and he proceeded. Perhaps Lordship can quash this and make the, instruct order the court to hear both the party and pass orders.
So, my lord, in this case, what I am saying, my lord, that it is not a fact that, it is admitted fact that this 133 proceeding can lie. And it was lied by the magistrate, lied by the session judge. That was not in dispute. Now they have suddenly, my lord, on absence on a single day, even the WS has not received from the second party. Although there was an instruction by the High Court that WS should be filed, that was not filed also. But suddenly, my lord, this is a task of the executive magistrate, my lord. There's something can be done, my lord, suddenly. So, my lord, this court can act, my lord, to interfere and protect my right, my lord. I mean, very much in jeopardized situation.
Lordship can go again to the police report once at page number 19. Whether it is a case under 133, for that I am placing. Page 19. Just read out. In enclosing here with the original petition submitted by petitioner, village so-and-so, lodged a written complaint petition at police station through the Honorable Court, which by stating that second party so-and-so have been created obstruction in use of the house part of complainant, which land is purchased from the original owner by the complainant, and presently second party members noted in so-and-so with criminal intention created obstruction by setting up trees and forcefully trying to create blockade. This is their complaint. During local inquiry about the contents of the petition, it is found that both the first and second party members are residing in the same village, side by side, and their dispute is going on with regard to ownership of the below mentioned scheduled park land, which is claimed by second party members as their own land. But during local inquiry, it is found that a said part used by the first party since long, and while the first party was working in Saudi Arabia for his job from year 2012 to 18, and his father lying on the bed due to illness, then the second party members with criminal intention created obstruction to the first party and also disturbed them from moving to the below noted scheduled land, which is purchased by the complainant from the original owner. And also the second party members illegally made a water pump which set up the trees by setting up trees on the said part. On the other hand, first party produced one Xerox copy of the land deed in support of his ownership, but the second party member could not produce any document and stated that if necessary they will be producing their document to the Honorable Court. During inquiry, it is found that second party noted are having power, manpower and very desperate type of nature and every chance of loss of human life and property, and will be assaulting incident second. So I beg to proceed under 133. Otherwise 133.
So from the report of the IO, it seems that there is no, the other villages are not
affected.
My lord, there is no findings in the police report. Police report has not saying that
inquiry, it is not any.
Inquiry, my lord,
Anywhere.
since I am the first
People
party.
of the villages are also affected.
Villagers are affected. It's a village road, my lord. So, naturally, my lord, it is the path of the villagers, my lord. I being the, because at the time of,
Is it a part of the villagers or it is the only path for your egress and outgress?
it is the path of the villagers. But the villagers, the other villagers can use the other paths by taking those. But this path is the only ingress and egress of my family, my lord. So, my lord, the other villager has not come because they are the opposite parties are very desperate in nature, very, my lord, powerful person. The villagers are very poor, my lord. In general, in village area, my lord, a single path cannot be created for a particular house, my lord. In village area, it is a village path, my lord. Although many persons have not come before the court, I approached before this court, my lord.
Because 133, the requirement is public, should be affected, and some way towards river and channel, if it is blocked, then it can be invoked. Construction of any building, disposal of any.
He is saying that it is goes up to Tungla.
It is written in the first paragraph of his petition.
Yes, it is the part of the village, yes, madam. They have written, madam. The below scheduled land is the path of the first party and other villages connecting to the river Longai. And without hearing me, my lord suddenly passed this order. Yeah.
So, even up, by the public for that effort block people pass but present from their help from their help. If further it was people can part of the person other and act in right? And then Panar and they are Panora and they are Panora with the people. But it is as people wait for art that on right box and for that by the company on for but what
Karimganj police.
Karimganj where is it? But there's one. So, paid by them. That part is that the part this time. Second part this. After one, done it. Drawn up the and after who from part get paid out of that wanted move or put in for data. The order of
My lord.
order of
Order of session judge. My lord, page 21. One. Page 26. The whole order discussed in here. Page 26 is the order. Page 21 and 26.
and by on 31 the division was but it was fixed, no? By
No.
executive magistrate.
Session judge.
No, by the executive magistrate.
Executive magistrate order, my lord, page, thereafter, my lord, page 27. After the session judge order.
No, after this session, prior to the order.
Prior to session judge, page 20, my lord. Last.
One date was fixed.
Date was fixed.
24
320.
I ordered that one order of that and did not order state that order started with one order. By the officer was asked that from it and was fixed on and it was before what it but without it but it responded did not appear to be regarded with photo regarded and five or different mention sport against the order of against the order of the represented by station judge and this number is similar to number 4 where sport it prepared order that 21 by the blood and 10/8/2021 is the order pulsary run at excavation.
Magistrate, madam.
And asking for by the of this statement according but thereafter you have appeared. Huh?
I have appeared.
13/6 both parties appeared.
On 25/5/22.
No. 13/6.
On
both the parties appeared.
yes, madam. 36 both. Yes.
Both parties appeared. Who filed on
13/10/2020.
no drop petition was filed on 25/7.
No, my lord.
Therefore, dropping the incident.
Yes. 25/7.
25. But subject on 25/7 was filed for dropping it and that was fixed for dating on 5/9. But surprising on 30/10 for the regarding court rather asked an order and doctor because public at large not right not right order for the chance of getting and password not by the other as it was where, but after the different what order they get that update by not as that or it was a big one positive get not only when of hard effect but from both that is the case of private part that present with may be affected by may be affected and one that have further cut of by the of each part that some of some of part but back of or that that or that one uh it or for to have made book application against the order of one but one is sort of that book one sort of division against what and another for the what the order of the court that whereby the by by from order perspective court it both parties were but but or both parties accept not but facts on the fact that it for the drop and so it the drop of that that one was by but were also by were part of the team of the team by Is there any date?
No, my lord.
It's already dropped.
Already dropped. So, my lord, my submission, my lord. One submission, 133 position, there is a public place. It is mentioned public place. And path is a public place, undoubtedly.
No, no, there's
So
a
this is
question
why.
of path is a public place, but it is your land you purchase. That land is used by you only, and the other side has claimed that it is the land purchased by them. It is within his tag and so on. So that is the disputed fact. For that reason, most probably you have to approach the civil forum. But yes, obviously, that the order was passed, the drop order was passed by the Rantek President in your absence. And that's why I thought that one chance would be given to both the parties to appear and to agitate the matter, whatever. And thereafter, if any result, whatever result outcome, then definitely the option would be that you should, approach the civil forum for appropriate or proper redress. That may be one of the options, but otherwise I have allowed your the order dated 13/10 is hereby set aside. If you do need any within 15 days or some days to appear before the judge,
Within 30 days.
within 30. Within 30.
Obliged.
I am sorry, madam, I was not. I couldn't attend at the time.
Anyway,
Calling
somehow
the-
your matter has been reached.
Yes, ma'am.
Anyway,
Sorry,
okay.
madam, for that. My lord, the appeal is against conviction of RI 4 years under Section 8 of the POCSO with fine of 5,000, madam.
RI for 4 years.
Yes, madam. Under Section 8.
8 of October.
Yes, my lord. And 5,000 is the fine amount. And 354, my lord, also 4 years SI. With fine 5,000, my lord.
It is 354 is SI or RI?
SI, my lord.
And the other one is RI.
RI, my lord. RI.
Also is RI.
RI.
And
354 SI.
354 is SI.
SI. Judgment date is 3/10/23, my lord. 3rd of October. So from the date of judgment, it is 8 months as on date, my lord. And during trial, he was 4 months in custody from 8/2/22 to 9/6/22, my lord. So it
they
is
were always the case of
1 year.
1 year.
1 year. And the punishment is 4 years, my lord. My lord, this is a case, my lord.
One thing you said, whether during the trial, he was inside the jail or he was outside?
Inside the jail, my lord. Inside.
Entire
No, not entire, my lord. He 8/2 to 9/6, my lord.
No,
Judgment
that
is
is the period, it's okay. Since judgment, he is
He is on-
custody. Custody.
no, my lord. At the
Apart
time,
from that, earlier he was 4 months. So I'm asking you,
earlier 4 months.
trial, while trial was going on, at that time he was in bail or he was in jail?
He was on bail, my lord.
Bail.
Bail. After filing charge sheet, my lord, he has been released on bail, my lord. So, my lord, this is a case, my lord, where the guilt is not proved beyond reasonable doubt, my lord.
Acha, just I'm asking, just the constituted one. I don't want to post the petition right now because what has happened that since Monday I'm not doing my best for 3 weeks. So it will be delayed again. On the today is the last day, we have to check all the orders and all. Then they are also going to Arunachal today by today. So may not be possible if it is. That is our main problem. Even if suppose I just work till 7:38, and they also work. But today they are having their pain by 8. That may be one of the problem also. I'll give him dictation that will be corrected and will be up to date. May not be possible. So can it be if your matter is, I think your matter is also urgent because he is already 1 year in jail. So if I can help you, just give us a date to Pariboni. And
if possible on Wednesday, might prefer.
Wednesday? 5-6, definitely. We'll try. 5. This on 5 because my personal problem is a bit different. Today I'm more and they will not be here for any correction and all. I'll be here at Guwahati. I'll moving by on Sunday, but they are going today. So if the dictation is passed, then it may be a problem for uploading and all. So let it be on Wednesday then. Okay, it will be 5-6. Okay.
Yes.
This on 5. Do you have any other?
No, I am for the victim.
Oh, you are being for the victim?
Yes.
Okay. We will hard on people. Otherwise, it could have been closed off. My problem is other way.
Yes.
That 2, 3, 4 long orders have I already dictated. Those will be, they will type it will be corrected and all, then it will be uploaded. So
I will be arranged.